May Your Lordship? Lordship, I beg to mention item number 2. With consent from the other parties, I'm representing on behalf of Mr. M. Chanda, conducting counsel. May I?
Two.
Yes, Your Lordship.
Respondent.
May I pray that this matter may be fixed next week, Your Lordship, on 6th, since he is the outstation counsel.
Okay. On the prayer of MS and London Council appearing on behalf of Mr. M. Chanda, London
Lordship.
Council for the respondent. Let this matter be listed on 6th
6th August.
06/08/2026.
Oblige.
May I please, Your Lordship? Lordship,
Yes.
may I humbly pray to mention item 12, please?
Hmm.
Lordship, the engaged senior counsel is unwell, so he won't be able to take up the matter today. And may I also please humbly pray to fix the matter on the 15th of September, please?
Oh, we got
15th of
criminal
September.
appeal. It's ready, I think. It's here, paper book are all ready.
Hmm.
But we, with the consent of the other parties as well, Your Lordship.
Can it be fixed for hearing? Final hearing?
I do not have the instructions for that, Your Lordship.
Has it been admitted? Let us see if it is admitted. We will list for hearing.
See the final.
Has it been admitted?
No, my lord, I'm for LAC, my lord, here. On last occasion, they have filed IA for bail, my lord.
Bail.
Hmm.
But there was some confusion and the matter was fixed for today.
It has come up for the IA today. It's come up for the IA. Has it come?
Actually, it was for
Yes.
IA, my lord.
I see.
It's
Nice. For suspension of sentence. Okay. POCSO, no?
I beg to mention item number 16, Your Honor.
60?
16.
16.
On behalf of Y. Bodoloy,
Huh.
for the appellant, Your Honor.
Hmm.
I've taken the consent of the other parties, Your Honor. This matter may be kindly fixed on 3rd of August, Your Honor.
3rd of August. On the prayer of Mr.
H. Thai.
H. Taj
Thai.
Thai,
Yes, Your Honor.
London Council appearing on behalf of Mr. Y. Doloy, London Council for the applicant. Let this matter be listed on 3rd.
Fourth,
August.
Lordship, 3rd is Monday.
4th. On 4th.
Obliged, Your Honor.
May I, Lordship? Lordship, I would like to mention item number 22.
22.
Yes, as the leading counsel he is not feeling well, Lordship. So I would like to seek your adjournment for that after 2 weeks.
What's wrong with him?
Sorry, sir. Since from
Not
yesterday,
feeling well.
yes, since from yesterday he is not feeling well. Just in the morning, I was told to go for ask for the adjournment.
Yes. But short term.
Up.
Okay. Mr.
NED.
N.
NED.
N. Yeri.
YEDI.
Yeri. Y-E-R-I.
YEDI.
E-I. N. Yeri. Got it? London Council appearing on behalf of Mr. M. Bagra, London Legal
Yes, Lordship.
Council. Submits that Mr. Bagra has some personal difficulty today. Therefore, fresh for listing of the matter after
2 weeks.
2 weeks. Praise the Lord. List the matter after 2 weeks.
Much obliged.
My lord, with the consent of the other side, my lord, may I pray, my lord, item number 3, my lord. I have some difficulty today, my lord. Can it be taken up on 25th of August, my lord? Item number 3, my lord.
Yes.
25th or 27th of August, my lord. Today I have difficulty, my lord. I have reached Gauhati late night last night. my
On the
lord.
prayer of Mr. B.K. Singh, London Council for the appellant, let this matter be listed on 20. When?
25th, my lord.
25th
Tuesday.
August 20.
Let's file. Let's file.
25th August.
Highly obliged.
Number 1.
You are supposed to file a status?
Yes, my lord, actually, I'm yet to receive brief from the earlier council, my lord.
How long?
My lord, I'm told he's out of station. He's out of station, my lord. I'll even text him for all this, for the brief and all.
Garbage.
So that is a difficulty, my lord.
Hmm?
I'm yet to receive brief from my earlier council.
Who is the earlier council?
Tagum Jamu, my lord.
He was last week, he was here. I mean, this week he was here.
But day before yesterday also, I've even called him and I even text him also, my lord.
These are difficulties. There is nothing remains, actually. What remains?
They have to file this present
Everything
status.
is in place. Waste management, everything, this thing, what do we call it? That has been installed already.
Yes.
And they are collecting the garbages.
Let them place on the record yours.
Not only in
Management plant
Huh?
also. Waste
Plant is
management plant.
already there.
Not yet.
It's
Your Lordship.
working.
Not yet. Your Lordship. They have to place on record your Lordship. That is where in the last occasions they have been given in to file in affidavits to place on records
Yes.
regarding the solid waste management plan, which is mandatory under section 12 of the solid waste management rule, your Lordship.
25.
Let them place on record, your Lordship. That is very important.
Plan has already been established.
Yes.
That been set up already. It's working or not?
We are still seeing lots of garbage are being dumped, and often when you go to the airport also, they are not doing a segregation part also. What we have seen when you go to that site also, still they are dumping the garbage in open spaces, and there is no landfill provisions are there. So this is where it's causing
If not,
the health hazards and the environmental pollution.
Yes, Lordship. I have spoken to them, Lordship. They have asked for some time, Lordship.
Sometime for what?
At least 2 weeks, Lordship.
To make it functional.
No, Lordship. So far the
Has it been set up? Plan has been set up?
It is set up, Lordship.
Where it is?
It is in my Lordship affidavit, Lordship. I am for 1, 2, 3, and 5, Lordship. I have filed, Lordship. Lordship, let it come up after 3 weeks and we'll that time I'll file the status also. IMC will of course file the status, Lordship.
If it is already set up, if it is functional, what remains here? Then Heard MS Ken Malik, learned counsel for the petitioner. Although this court had observed that if no affidavit is filed, the matter would be heard on the basis of materials available already in the record. On the prayer of MSG at Learned Addition Senior Government Advocate, as well as Mr. L. Kurdu, Learned Standing Counsel, IMC. Last opportunity is provided to bring on record the status of the list the matter after 3 weeks. Just say.
Oblige your
Item number 4. Lordship, in this, I have received instruction yesterday only, Lordship, from the Department of, from the Deputy Commissioner, Upper Subansiri, and Lordship, the Forest Department has written for extension of times or seeking time, Lord. So some more time may be allowed.
This also connected in respect of
Yes.
this place.
This is in the Porejo, my lords. This is in the Porejo, my lords.
Waste management.
Same. That earlier one is of Itanagar and Darla.
Internal capital region.
Okay, so we'll grant him. Heard Mr.
P. Yobin, my lords.
P. Obin,
My lord.
Learned Counsel for the petitioner. as prayed for by Mr. M.S. G. London Additional Advocate, Additional Senior Government Advocate. Further, 3 weeks' time is granted to file affidavit in opposition.
Malad, may I pray for a date of 25th, if convenience to my 25th of
on
August, my lord.
3 weeks on 25th August.
Malad. Much obliged.
Obliged, sir.
Item number 5.
In item 5, today we are filing the affidavit, my lord.
You have not filed the affidavit earlier.
In fact, affidavit was ready. It was in the file. I thought that it was filed, but in fact, it was not filed. It was ready. Today we are filing it.
Heard Mr.
T. Tatak.
T. Tatak, learned counsel for the petitioner, for the appellant. Mr. Next para. And learned additional advocate submits that an affidavit in opposition would be filed during the course of the day. Mr. Therefore, phrase for listing of the matter after a week. After a week. Yes, sir, after a week.
After a week.
Praise the Lord.
You'll be filing.
List the matter after a week.
Obliged, my lord.
Item number 6.
Lordship, this writ appeal is directed against the final judgment and order dated 18/5/2026 passed by the learned single judge in WPC number 509 public 2025. The fundamental issue for the determination before this honorable division bench is whether the Arunachal Pradesh Public Service Commission can arbitrarily exclude candidates possessing a B.Ed special education degree from the recruitment process for the post of postgraduate teacher PGT when the governing recruitment rules and advertisement number PSCR A01 stroke 2025 dated 16/8/2025 merely prescribed second class master degree in the concerned subject from a recognized university with B.Ed.
Obviously not. They cannot arbitrarily do that. Then
And neither the recruitment rule nor the advertisement exclude B.Ed special education or stipulate that candidate must possess a general B.Ed.
police notice.
General special B.Ed.
एक issue है. Only one, my lord,
Where is the advertisement?
Advertisement.
Page 81.
It is in
51.
page
81.
It only said B.Ed in the advertisement.
Yes.
No, not 81.
No, it's not.
81 is something different.
Use that. 87. 87.
87.
pagination is not in order. That's
Where is the qualification? Okay. Second class master degree in concerned subject from recognized university with B.Ed. What is the difference between B.Ed special and general?
my lord, B.Ed special is is a special educator to impart education to the person with disability, my lord, children in need of the care, my lord. And the general B.Ed is to impart education to the children, normal children, and for that, my lord, say class normal school and in the school, my lord, and for the special institution for the person with disabilities, for the requirement is B.Ed with special, my lord. Special educator, B.Ed special educator. There's a difference, my lord. And for B.Ed special educator, the teacher-pupil ratio is to be there, my lord.
For
Say-
special.
Yes. Say for 10 student, 15 student, one special educator, 10 student, one special educator, like.
Then
For-
B.A. General.
B.Ed general is there's no such great my lord. But the present
So
post,
B.A. General includes B.A. Special.
no, not include. B.Ed special is altogether different.
You have not said B.A. General.
That is not
But-
there in the.
B.Ed is B.Ed. It's not mentioned B.Ed, but when it is not mentioned B.Ed special matter, it's always enforced as a B.Ed
Your
general.
inference will not do.
But the thing is that requirement.
Page 89 says university with B.Ed.
My lord, this the letter, my lord, the clarification has been done, my lord. This was issued by the APCS, my lord, because this postgraduate teacher is for more than 100, my lord, is for imparting education at normal the classes, schools, my lord, and not in the ratio of the pupils teacher ratio, my lord. Because even in the state of Arunachal Pradesh, we have a limited, we don't have a in other.
What is the period for obtaining this B.Ed special?
Is my lord
Course length, that means.
course length, my lord. That is the course length is the entire course. It is structured by the rehabilitation commission is there, my lord.
Council of India.
That is regulated by them. And
Rehabilitation Council. Of
yes. And B.Ed general is just regulated by the teacher education.
Where is the recruitment rule?
Recruitment.
Where it provides that only B.Ed.
This could have been clarified by corrigendum.
Yes, it has been clarified. Later on, they have challenged that corrigendum part.
Also.
Rejecting, they have to challenge the rejection, my lord. That was after
Where is the corrigendum?
Because if it is only B.Ed, naturally, someone with B.Ed special education would also like to apply.
Yes, 314.
So much scarcity of jobs.
corrigendum.
Where is this?
The special B.Ed is for teaching persons with learning difficulties.
Yes, ma'am.
Something like that.
Yes, ma'am. And for that, we have not yet the RR has also not been created, and the post for the middle class up to class 1 to 8, my lord, the post is being created, and simultaneously the recruitment rule also being framed, my lord. And there's no recruitment rule as on today, my lord, in respect of B.Ed special.
Page 140. It has been clarified.
That's true.
Well, issue notice.
It is still.
Yes, it's already over.
Lordship,
It's
Complete
already
already appointment and recommendation, everything now.
they have already joined also.
Already posted.
Yes,
Yes.
my lord. And this, my lord, in the format of the writ appeal, my lord, the altogether 100 the petitioner were there in originally in writ petition. Now in this present writ petition, writ appeal, only 2 of them.
Doesn't
It's-
matter. It may be one also.
Well, that's all right, but
Subject matter.
since it is a continuous proceeding, my lord, the rest of those ought to have been made as a co-respondent, my lord. That has not been done because this is a writ proceeding, writ appeal. It's a continuous process, my lord.
Who have chosen to appear, they get whatever the outcome, they will get the benefit if it's in their favor. But otherwise, notice.
Yes. Heard MS D. Rilung,
Yes.
learned counsel for the appellants. This intercourt appeal is directed against the judgment and order dated
18/5/2026.
18/5 2026 passed in WPC 509/2025, whereby the writ petition filed by the appellants has been dismissed. List of the challenge in the writ petition is to the was against the rejection of the
Order of your,
candidature.
the order of yours also in this writ petition.
Is it there?
Interim, some kind of interim order is.
That was interim.
It's okay.
Finally, this was by somebody else.
Yes, obviously.
Lordship,
My brother has pointed out, and in the motion stage, this court has issued a
Yes.
notice.
Yes.
Passed in there. Any objection to take up this method by this bench?
Final adjudication is
No, my lord, no.
by a different person.
We can examine.
Objection? No objection. Okay. Against the rejection of the candidature of the appellants as regards the education qualification, particularly the B.Ed special education list of. That's all. Issue notice returnable by 4 weeks. All are represented
Yes.
My lord.
as MS. Who is one? MSP Pangu, Learned State Council, Mr.
2, 3.
MS Enanju, Learned Standing Council, APPSC, and Mr. T. Tagum,
4 and 5.
Learned Standing Council. Education Department enters appearance accepts notice on behalf of all the respondents. No formal notice need be served. Our extra copies of the writ appeal be furnished to the Learned Council for the response.
Item number 7.
Yes.
Well, I find it to be a very unique case because the differences between the skilled and unskilled, my lord. And then here the government, they regularizes MTS, and we falls in the category of skill. And then they have issued a memoranda where they says that common seniority list of skilled and unskilled MTS should be maintained. Then thereafter they frames the recruitment rule, but then skill MTS has been removed from the recruitment rule.
For promotion?
For regularization.
Regulation?
For regularization.
As MTS?
As MTS, my lord.
What is the status of a skill? Skill?
Well, it's nothing, my lord. Say, for example, like if I fit for a plumber, so even if I'm skilled for the plumber only, and same person who is also skilled, but he is appointed as MTS unskilled. So as per requirement, and this post, my lord, they are appointed on need basis, and they have already spent their youthfulness, my lord. And
what's the recruitment rule?
Recruitment rule, my lord. But just find out. Page 41, my lord. There's 2 recruitment rules they have framed it, my lord.
Which one you are challenging?
Both. 21.
41.
21 recruitment rule, my lord.
Page 41 is
46, my lord. 46. Page 46, my lord.
The rules may be general multitasking so and so.
My lord,
amongst the serving unskilled contingencies is
my lord, if I'm allowed to assist the court, by reading
just wait.
Yes, ma'am.
Just a minute.
Page 46. Ah, correct. Correct.
Which part? Which is the offending thing?
My lord, just, my lord will kindly come back to the first paragraph. First paragraph, line 4, my lord. After word cobbler and, my lord, equivalent post and equivalent post. So what I understand is, my lord, both skill and unskill are equivalent, my lord. Then, my lord, kindly come to, my lord, kindly come to 2, serial number 2, my lord, clause 2, amendment to the schedule of the principal rules, my lord.
Yes.
There, my lord will see in the schedule of column 10 of para B for the existing paras, the following shall be substituted, my lord. 50% of vacancies shall be filled up from amongst the serving unskilled contingency staff stroke auxiliary labor corps casual laborers with minimum 15 years of continuous service in their respective office stroke department and possessing education qualification of class 10 ITI or equivalent pass certificate from a recognized board of institution. The selection shall be made on recommendation of the departmental selection committee on the basis of seniority, performance, so and so from the so and so. Now, my lord, kindly come to note. In the note, there is a Roman 2, my lord, down below in the same page. Seniority for regular appointment to the post of multitasking shall be considered from the common seniority list of all aforesaid categories maintained by appointing authorities in terms of OM numbers 2011 dated 2012. And my lord will kindly find this in the memoranda, will find at page 37, my lord.
Page
37. It says,
sorry.
Subject procedure for maintenance of common seniority list for skilled and unskilled contingent, my lord. They have rightly, my lord, followed this. They have rightly followed this. Our name is also there, my lord. Then, my lord, then kindly come to page 53, my lord. The common seniority list which they have prepared on the basis of this office memorandum 9 January 2012, my lord.
Skill.
53, my lord, annexure 6. My lord will see here in the combined interstate seniority list of DLF, both skilled and unskilled contingency workers of civil aviation department has been prepared. So
this is for skill and the unskilled. There is a common seniority.
Yes, my lord. That in terms of
now come to the earlier rule, original rule,
memorandum.
Original rule.
Original rule is at page 40, 30, not 30. Memorandum, my lord. Memorandum.
No. Rule. This
rule, my lord.
This page 46 has been. It has amended the earlier rule.
Page 41. Yes, the original rule.
Original rule is 41, my lord. 2019, my lord.
Column 10 of para B.
Here, my lord.
50% direct recruitment on the basis of marriage and just so.
In the short title, my lord, skill has been removed. My lord, in the short title number 1, my lord, kindly come to last line. first first paragraph. And equivalent post. And equivalent post.
No.
One, my lord, in
This
title.
10B has been.
No, my lord, this rules may be. I'm referring to this for one purpose, my lord.
And equivalent post.
Equivalent post.
10B, column 10, para B has been
removed.
Amended.
Amended, my lord.
What does it say? The 50% vacancy will be
that
page 44.
44, my lord.
Fill up from among the existing unskilled contingency staff who have completed 15 years of. This also says about unskilled.
Unskilled.
Huh?
Then, but my lord,
what is the change here? What is the change here? Amendment is what?
Which skill has been removed.
No, skill is there.
No, unskilled, my lord.
The unskilled is there. Page 44.
Yes, we are skilled, my lord. We were also unskilled initially.
What we are asking, my brother's asking is that which amendment has has been found to be offensive by the petitioners?
This rule.
This removing of skill.
Yes.
According to you, it's removal of the skill.
Not mentioning.
There's no mention.
Not mentioning. But then they, my lord, in the title, third line, my lord.
You just read page 44.
Correct.
Para B.
Para B, yes.
10B.
Yes, my lord. 50% of vacancies shall be filled up from amongst the existing
unskilled contingency.
Yes. The word, my lord, we are skilled. We were also unskilled.
Here also this amendment,
my lord,
is also unskilled.
Yes.
Then,
so therefore, my lord, the question is now, if my lord will.
Before that, what is the difference between this original rule and this amended rule? It talks about unskilled only.
Unskilled.
Both the rules talks about the unskilled only, not skilled.
Not skilled, my lord.
So what is the difference between the amended and the original rule?
But that's, my lord,
that's why you are challenging both.
Yes.
Now, I just would like to know what is the
46.
difference between this amended and the.
My lord, the word removal has occurred in page 46, my lord. Note Roman 2, seniority of the committee. Earlier, it is nothing but the multitasking staff only, my lord. And we also falls under that category. And our initial appointment was unskilled. And we were given one promotion as a skill, my lord. And thereafter, we don't have any promotional avenues. No, it's correct. Our is that.
I just wanted to wanted to know what is the difference or addition and deletion between the original rule and the page 46 amended rules.
Original rule, so there is not.
It talks about unskill only. Nowhere it talks about skill.
No.
What is the difference? How it has been amended?
What has been changed? That means.
My lord, only it is unskilled. It is unskilled only.
Earlier also unskilled.
Earlier also unskilled.
Now also unskilled after amendment. So what is the difference?
Now they have in page 46, they have incorporated, my lord. Can we come to the page 46 for a moment?
They have incorporated
Roman 2, my lord. Note after the note.
Seniority for regular appointment to the post of multitasking staff shall be considered from the common seniority of all appropriate categories maintained by appointing authority so and so.
That is, my lord,
so common seniority has been maintained.
And this is in terms of, my lord, this office memorandum dated 9/1/2012, page 37. It is their own policy.
So what is your submission?
My submission is that, my lord,
how it is.
We also should be given opportunity for absorption as an MTS, my lord. Multitasking staff. Because
so according to by this rule, it's only the unskilled, not the skill.
Not the skill. Because
skill has no other avenues.
No avenues, my lord.
No avenues.
Yes, my lord.
Is it so?
No avenues, my lord.
Is it so?
Yes. In their affidavit, my lord, they have said one thing. In their affidavit by the respondent 1, 2, and 3, and the 4, they have said they have filed, they have made one statement and annexing recruitment rule of the LDC, lower division clerk. So there what happens, they have provided that 15% post is reserved for the skill, but the through a limited departmental examination. So what we are saying that, what our submission is, my lord, since our initial entry into this department is a unskilled, my lord, and by dint of our long period of service, they have enhanced our financial position, finance salary by giving a title as a skilled one. That is the only difference. So what we are saying is, when your office memorandum itself says, you know,
as a skill, what you are getting? Are you getting higher pay, higher, I mean, remuneration? Are you getting, sir? Are you getting?
no, my lord. Only difference, only difference is the skill is we are asked to sit in the ticket counter of the.
It's better. And unskilled, they'll be in the gate.
I don't know where they are deployed. My lord. That is the only difference.
So what is this? What is the remuneration you are getting?
Same.
Skill and unskilled.
Skill and unskilled. Only 200-300 difference is there.
Maybe.
Yeah.
Maybe 1 rupee.
1 rupee.
There's
or
a
two.
difference.
Correct,
You're
correct,
getting higher.
Higher
Higher wages.
I agree with that. So
And avenues? No avenues at all.
No avenues at all.
Are you sure?
I am sure, very sure. Except for one recruitment rule which they have come out with is keeping a 15% reservation for the MTS.
50%?
15 through limited departmental examination. So, my lord, we don't have that education.
What is the nature of the job?
Nature of job is nothing, my lord. We are basically
Same or different?
Same.
Little different or same?
No difference.
Is there any difference?
Even we can be put in the field. No. Subject to the satisfaction of.
So you think that the skill should also be given, skill employees, skill MTS, in this category should also be given an opportunity of this absorption.
That is the only argument.
When making this distinction and not giving them is discriminatory.
Hostile discrimination. That is my only simple ground. That's why I'm finding it very unique case. Because never ever I have seen any recruitment rules where there is no promotional avenue.
If we accept your submission,
correct.
If it is the law and supported by law, it's a very, good case for you. It's not a unique case.
Malad, can you try to see Ajit Singh judgment? Malad? Ajit Singh too is the important judgment in this case because although it is not a fundamental right to claim promotion or the regularization, but then must consider for the promotion. That is the first principle of
it's
law.
Not a case of promotion.
It is not a
it's
case
a case of regularization.
It is case of regularization.
So Ajit Singh goes.
Ajit Singh goes because that's why I was thinking of relying on that. But then somehow that principle, if we take the analogy, my lord,
rule is for regulation only, not for promotion. It may amount to promotion, but then it's not a promotion as such.
Yes.
Is not it? Yes. How can you do that?
My lord, first of all, factually, my lord, the skilled also, they have a promotional avenue. My lord.
Skill
they have.
How?
We have
any rules for the
yes.
Any rules
they
for the
have
skill
yes. To the post of LDC. And there are other promotional avenues also for the skill. This is the fact. We have categorically stated in our affidavit also.
So what is the difference between skill and unskilled?
Skill is upgraded. It's from the unskilled. Some are directly appointed as skilled. Some are upgraded to skill.
So they have
they are
better avenues and better remuneration.
Yes.
Higher. Kind of higher in rank.
Yes.
Kind of thing.
Yes.
Then how you have the common recruitment? Seniority list.
Common seniority is a different thing. There used to be maintained common seniority amongst the skilled and unskilled. That is another thing, Malad. But now the recruitment rule for this
skill
MTS only talks about unskilled because from the unskilled, this is the promotional avenue.
50% will be filled up by regular unskilled. Having certain qualification, which qualification.
Those who are unskilled.
And
or
a qualifying years of service.
Skill they will have for they will have their different.
They have the different recruitment rule.
Yes.
Let us see.
99 of their application.
They have a different recruitment rule. Where it
You-
is?
In our affidavit, my lord, we have
Page 99.
In the recruitment. I think
we have made a statement in
page.
page 79, my lord,
Annexure 5.
para 15. So I'll read the subpara, my lord. The fact is that while only eligible unskilled contingency staff can be appointed to the post of multitasking staff, daftari, peon, chokidar, mali, barber, cook, washerman, cobbler, and equivalent posts, as explained in para 14. On the other hand, the eligible skilled contingency staff can be promoted to higher posts of lower division clerk through limited departmental competitive examination conducted by so-and-so, so-and-so. And then we have given the recruitment rule.
Where is the recruitment rule?
Recruitment rule will be at page 97 onwards.
97.
Yes. LDC.
Rules for general organizational groups.
Basically the job. LDC, their skill, therefore they possess certain qualifications, certain skills. The MTS, which includes all this daftari, peon, chokidar, these are unskilled. These are also men by unskilled.
But on contingency.
Contingency.
But for regular,
they have
been as per the rules, they can be regularized, having as the MTS.
Yes.
In those posts, who has rendered 15 years.
Yes.
With certain
those are unskilled. Yes. From the unskilled staffs, those who have skills, they are upgraded, promoted to skill.
25% of vacancies
with those who have education,
That's
better
fine.
education,
But
qualification, better qualification.
But can't the skilled persons who are in a way more qualified? Than
Yes,
the
my lord.
unskilled,
Exactly.
Can they also not be given the benefit of absorption?
My lord, recruitment rule therefore has been framed for the MTS because my lord has seen what are the posts under this MTS. These are daftari, cobbler, mali, chokidar, peon, barber, cook. These are posts, my lord, the nature of work which does
not
require any higher qualification.
So this skill, contingency.
Yes. They have a higher.
They work as
they have higher skill. Yes. They work.
According to practically this skill contingency stuff.
They are also working as MTS. That's what.
No. They are as skill. They are under the skill contingencies. They are in the office, department office, but not doing this unskilled jobs.
That's why I was asking, what is the nature of the duties and responsibilities or the job?
That, my lord, the nature
between of both skill and unskilled.
Yes,
contingency.
Of course, we have not made any specific averment to that effect. But
so your stand is that since they have an avenues,
yes,
for promotion and the separate recruitment rule,
yes,
there's no. I mean, the rules for regulation of the it's not offensive.
My lord, my submission will be that whether overqualified will be a ground for disqualification.
We are not
recruitment, whether the government has the discretion to frame a recruitment rule only bringing in the unskilled for certain jobs,
no.
excluding the skill contingencies. Only.
No, one could understand, we may accept it if you say that skill has a different nature of work.
Yes.
Right?
Yes.
And they have a separate recruitment rule, which can be promoted to higher post rather than the MTS. is because they are already as good as working as in the MTS. Therefore, they have the promotional avenues and regulated by other rules. In that case, one can understand, but simply because the skill by name itself amounts to, has a, little higher, wages. That cannot be a ground for.
My lord, actually, that cannot be. For being skilled, there will be certain higher qualifications.
Skill or unskilled.
Yes.
You are working. They are working as MTS.
Yes.
On contingency, right?
Contingency.
So there's a provision for regularization of unskilled. Why not skill?
Yes, my lord.
That is the whole issue.
Yes, that is the whole issue, my lord.
Their substantive, job is working as a contingency staff.
Same.
No, my lord, the contingency staff also, the nature of job, it's totally different. Unskill is different, skill is different.
So that is why
my lord, if that is required for the nature of job, what is the nature of job? Obviously, it will be different because skill contingency will have.
Sir, you're saying obviously it will not be. We understand it will be obviously by name itself, by nomenclature, by designation itself, it will have.
Yes,
but so as there's a
if
difference.
that is required, then
But at the same time, you cannot forget they are still the contingency staff.
Daily wages. No, not daily wages. They are getting the skill salary, man. Although it is.
You don't have a separate kind of rule for skill, except to where is that 100? Where do you get it that they will be promoted? To the post of LDC.
LDC.
This LDC rule 97 is the rule.
99
for LDC.
2019.
99.
Yes.
Page 97 it starts. Starts 99.
8 and 10 is important for us.
25% by promotional MTS through limited department, 15% skill contingent staff. This is what you are relying.
Yes.
Right. 15%.
Is in page 6, if you see, you have given so much of space for the unskilled. Given so much. That's going to page 6, 46 of my reading. They don't have any so different.
Maybe lesser.
Yeah.
This is for regulation. There is something we need. What do you say? Anything? So how they are appointed?
My lord.
Complete.
Engaged, skill or unskilled?
On need basis.
No, my lord, initial appointments are on need based, my lord. On need based.
No. How? Suppose there are two persons.
Yes.
Having the same the qualification or whatever. How it is the manner of appointment as contingency, distinguish. How you distinguish it should be appointed as
yes, my lord, of course.
Unskilled and it should be appointed as skill. They can be appointed at the time also.
Yes. It will be a higher,
as you have
higher qualification for skill.
On the basis of higher qualification.
Higher qualification or some specific specialties.
Where it is?
No, that we have not. Otherwise, appointment of
there must be some office member are not
unskilled.
There may not be a recruitment rule as such,
yes.
but then 30 rule may,
for skill
309 rule may not be there, but you may have the office memorandum.
Yes.
To regulate the appointment of contingency,
yes.
The skill and
yes.
unskilled contingency staff.
Yes, yes.
Where it is?
But that we have not.
There must be something, is not it? That may have a relevance. No,
Page 53, my lord, there is charter of duties. Charter of duties, how they are deployed.
No, we just wanted to know how you are appointed.
How the skill and
The manner of appointment,
Manner of initial appointment.
method
the
and manner of appointment.
manner of distribution of duties also.
Yeah.
To the skill and unskill.
Well, it is completely on the need base. Suppose if the ticket counter, in the ticket counter of the civil aviation department.
No, how you distinguish? Suppose there are two persons.
Yes.
One may be both of you. Mr. Tara can be appointed as skill. And Mr. Bam can be appointed unskilled at the same time. How it is regulated? Any office memorandum?
Nothing as such. It's daily wages only. They are appointed on daily wages. And then, my lord, kindly see page 53 for a moment, how they are deployed.
53 of
writ petition, my lord.
Writ petition. Writ petition.
Yes, my lord. Page 53.
53 is the seniority list.
Yes, my lord. Duty entrusted in the extreme right, my lord, will find.
Ticket counter.
Duty entrusted, ticket counter, luggage carrier, my lord, same. And the qualifications are also some, my lord, Tapan Kumar, they kindly see skill, class 12 pass, ticket counter, then skill, class 10 pass.
Similar duties given. Yes. Unskilled is also in ticket counter and skilled is also in
skill.
Yes, sometimes.
Nature of job is same.
Class qualification is also same. Some are unskilled, class 12 pass.
My lord, very interesting part is this 14, serial number 14. Pema Karbi, unskilled, is class 12 pass. Is private respondent, class 12 pass. And then Alo ticket counter.
So this qualification on the basis of qualification, classification on the basis of qualification falls flat now.
No, my lord,
That's why we would like to know the manner of initial appointment as a skill and unskill. Because some of them having a class 10 pass, they are skilled.
Yes.
Some of them have the class 12 still, then they are unskilled. How it is appointed?
My lord, what I've been told that there are specialized qualities like driver, even the electricians.
What kind of specialized when the class?
My lord, I'll get proper instruction how they are appointed. Otherwise, only as per the affidavit, our thing is that the recruitment rules say so.
What kind of specialization? Class 10, class 12?
No. In any particular job, for any particular job, my lord. For any particular job, the specialization.
See, by this page 53 is right.
Yes.
Someone who has class 10 pass is also a ticket counter and skill. Someone is having a class 12 is unskilled.
Yes.
And in his ticket counter.
Yes, that will have to take.
I think it will have a relevance.
The manner of
appointed initially.
So, what about the pleadings? The affidavits are there.
Yes.
All have filed affidavits. Already.
We have filed affidavit.
Okay.
All have filed.
The pleadings are complete.
Completed.
Here. But this aspect you can bring on record.
Yes,
perhaps.
my lord. This clarification.
Then it's ready for hearing.
The initial appointment.
One more thing is, Mr. Tara,
my lord,
you have been given there is a provision in the LDC recruitment rule that skill continuous step has been given 15% of the total post for promotion to the higher post.
No, my lord,
because skill or unskilled, they are regularized, they are entitled for regularization in the MTS, as MTS. But skill, the petitioners, they have the
still higher up.
Higher up in the, as LDC. Although the percentage may be less.
This rule itself
it's in the lower rank only.
Well, this rule itself is not sustainable. Kindly come to page 99, then I'll take their lordships to page 46 of my writ petition. For unskilled, they have done so much, my lord. My lord, kindly come to column 8, my lord.
Page?
Page 99, LDC recruitment rules. As per
Page 99.
99, 8. Whether whether a column 8, whether age and educational qualification prescribed for direct recruit will apply in the case of promoting. They said age as per the Arunachal Pradesh civil service and civil post upper age limit for direct recruit rules 2014 as amended from time to time, so and so. Education qualification class 12. Then my lord has seen like we are class 10 only. Then first thing, we are not eligible at all. The second, my lord, will kindly come.
Not all.
No.
Some of them.
Yes, madam. They kindly come to 10. 25% by promotion from MTS through limited departmental competitive examination. That means because I don't have class 12, I don't have class 12 pass certificate. So at the first instance, I'm not.
Not all of them. Some of them.
No, all the petitioners, madam. Three of us.
Class 10, sir.
Class 10 only.
Then you join you work as a unskilled.
My lord, the department is given this promotion. Anyway, kindly see, my lord, at the first instance.
It's a kind of promotion.
No. It's a promotion.
Initially,
my
you're appointed as, engaged as?
Unskilled.
Yes. And promoted to skill.
Yes, because of a long dint of service, my lord.
And your qualifications.
Yes. No, qualification class 10 only, my lord.
Oh.
So we are not. And my lord, see this.
You forgo the promotion as a skill. Then you will also be entitled.
No.
You remain as an unskilled.
There's one thing, my lord, kindly appreciate this.
Because it's not completely your those are because if you don't have the qualification, what can we do?
My lord, kindly see two things. One, column 10, matter of the recruitment, whether by direct recruitment or by deputation, transfer and percentage of the vacancies to be filled by various methods. The first method is 25% by promotion from MTS through limited departmental competitive examination. Now, I am not an MTS now because I am unskilled initially. I was given a small financial benefit, so designation has been changed to skilled. That's what. And kindly see this, there is limited departmental examination. So my qualification is not commensurating with the schedule 8, class 12.
So now you are not challenging this?
No, we are not challenging, madam. Even then, kindly see, madam, then 15% from skill contingency staff. But the discrimination is so high, what heaven would not have fallen, my lord, if they have
discrimination would come when parties both are equally situated.
Correct.
You are in a higher position. By your own submission, you said you have been promoted or elevated to a skill.
I cannot tell lie, my lord, because there is a categorical statement in my read petition. No, my lord, kindly.
No, we appreciate that.
No, my lord, kindly come to page 46. So
even if you try, also will not accept it.
No, my lord, fine.
It's a question of telling a lie.
No, kindly see, for the unskilled, my lord, kindly see, so much of leverage scope has been given to the kindly see page 46, my lord, number 2 amendment.
Your writ petition.
Yes. There's 13 July 2021.
Yes.
Serial number 2. In the schedule of column 10 of para B for existing paras, the following said page 46, my lord. Yes.
You're reading 2.
2. I'm reading 2, my lord. Okay. 50% of vacancies shall be filled up from amongst the serving unskilled contingency staff, ALC, casual labor with minimum 15 years of continuous service in their respective offices, department, and possessing education qualification of class 10, stroke ITI or equivalent. These, I don't know their wisdom. Why are they repeatedly using the word or equivalent pass certificate from a recognized board or institution? The selection shall be made on the recommendation of departmental selection committee on the basis of seniority, performance, punctuality, and integrity certificate. The candidate who do not, my lord, this is offending again. The candidate who do not possesses aforesaid requisite qualification and appointed prior to 1st June 2010 shall also be considered for appointment to the post along with other candidates subject to fulfilling of requisite requirements like seniority, performance, punctuality, and integrity certificate by the aforesaid selection commission. Now you have created so much of scope for the unskilled. So whereas in this case, my lord, even this page 99, as my lord has seen, all my roads are blocked. There is no promotional evidence. Neither I am here nor there.
No, because you are not unskilled. You have accepted the skill.
Yes, my lord.
Contingency.
No, but only a small financial benefit. But my lord has seen at page 53 how we are deployed, my lord. How we are deployed.
Okay, we'll admit the petition list for hearing.
Yes.
In the meantime, you bring on record this, right?
Yes, madam.
It would be better.
The difference in the
Because you would like
entry
to
of
mode of recruitment.
yes, mode of recruitment of skilled and unskilled.
Mode of it could be.
Well, till then there is a
It will be engagement. So you consider that engagement or recruitment. Or,
engagement. Yes.
Mode of recruitment or engagement.
or we'll admit him.
Actually, it can be fixed for hearing. Finally.
We'll fix for hearing. We'll admit the petition. We'll fix for hearing.
Well, till
And
then,
in the meantime, he may bring all this mode of recruitment or engagement of the contingency and the unskilled and skilled.
Yes.
well, that's
All right.
A small interim prayer is there that
What?
may be considered.
What?
Restrain the respondent from filling any future vacancies under column 10B of the Civil Aviation Department only. That much, my lord, because if admission and all those things, it will take time.
It's Mr. Tara, it's a challenge to the virus. Difficult.
Even
that's why we're admitting it. We'll give you a fix date whenever you like. Because we would like to know. Otherwise, we have heard you. I mean, we have heard, but then we'd like to know how this thing, how you are all skilled and unskilled are appointed.
Yes.
My lord, can you keep it in the admission column?
Huh?
Kindly keep it in the admission column. Only that instruction learned additional advocate general will bring on.
Okay, it's up to you. Otherwise, we see again on for admission is not compulsory. I mean, mandatory that we'll dispose of.
Everything has to be.
Everything will have to do. It's for you only. We're saying that we'll admit the petition list for hearing.
It necessitated a hearing.
Next
Full hearing.
Sort it. Admit for hearing. Sort it.
It's better to fix for hearing.
Yes.
Sort it.
Keeping it.
In the meantime, you can bring.
Yes, madam.
Bring.
Heard Mr. T.T. Tara, Learned Senior Counsel, assisted by Mr. G. Bab, Learned Counsel for the petitioners, and also heard Mr. N. Ratan, Learned Additional Advocate General for the state. Next para. Admit list for hearing
on 4th August.
4th.
No.
Can you bring it?
Short for bringing it on record.
No, only instruction has to obtain.
We'll
Actually, let us give them 2 weeks at least.
Yes.
40.
After 2 weeks
11.
On 11. It's a Tuesday.
Yes.
Tuesday.
11/08/2020. In the meantime, Learned Additional Advocate General may bring on record as regards bring on record the mode of recruitment engagement of the skilled as well as unskilled contingency staff. Right.
All right. And also the nature of
that you bring.
No, that is 53 already. It is dealt with. Obliged.
In that case, mode of recruitment and nature of duties and responsibilities of the skilled and unskilled contingency staff.
Item number 8.
Lordship, this is for the protection of public property.
Public property.
Yes, Lordship.
What public property?
Lordship, NIT, that Jote, actually, as per the land allotment, it is of the 301 acres, Lordship, from beginning. And now, it is only 133 acres only covering, Lordship. Whereas this NIT displaying the yearly land revenue till today for the 300 acres, Lordship. And now, because of this 100, Lordship, they have filed.
They filed.
Yes,
My lord,
Lordship.
do we have filed the affidavit? My lord, do we have raised the, my lord, approved objection, the mental of the present PL, my lord? If your lordship says, my lord, who is the petitioner, my lord? My lord, he claims to be a social activist, my lord. Now, my lord, allegation has been, my lord, alleged, saying that.
Just wait. Who is for 3 and 4?
Mr. Rintu Soika, last time he appeared for NIT, my lord. It's a primary institute, your lordship is aware, my lord, National Institute of Technology.
We directed 3 and 4 to file affidavit.
Lordship, they have already filed.
They filed, I think.
3 and 4.
Lordship, their frequent change of the legal standing council we are facing, Lordship. Standing council, they frequently change the standing council.
The office note says that no affidavit has been filed on behalf of 3 and 4.
Lordship, 3 this standing council has been changed during.
No, we are not interested in changing. We just wanted to know whether they would like to file the affidavit or not.
They have
Lordship, they have filed
They have
affidavit.
filed,
Lordship.
NIT, they have filed.
Then what this office note?
Lordship, just simple direction for demarcation of the Lordship.
Demarcation of the land.
Exactly, Lordship.
Alleging encroachment.
Lordship, 166 acres, losing the 166 acres for the NIT institute, like NIT is big loss for the Lordship state. Lordship,
166 is the total area.
Lordship, 301 acres, and now only 133 acres has been Lordship given, whereas we are paying for the 300 and allotment also, Lordship. Now because of this,
list for admission. You have received the affidavit. Where is the affidavit? Correspond 3 and 4. Yes, it's here. Then why office notice is no evidence by response 3 and 4. This is the affidavit of response number 3 and 4. List. Sir, we'll list it for admission. We may dispose it on that day. I'll consider everything, including maintainability. We'll list it for admission.
Lordship.
Heard Mr. G. Kato, learned counsel for the petitioner, as well as Mr. Archana, learned additional advocate general for state respondent. Although, no, office note 27/07/2026 reflects that no affidavit in opposition has been filed on behalf of the respondent 3 and 4, the records speaks otherwise, as the petition respondent number 4 had 3 and 4. An affidavit in opposition on behalf of respondent 3 and 4 has already been filed. As agreed to by parties, let this matter be listed for admission after 2 weeks.
That's it.
You kindly inform the standing council for institute.
That's it.
Item number 9.
My lord, item number 9, my lord, one thing, my lord, just I like to highlight, my lord. Here, my name, my lord, I'm not in the list of the legal aid council. I'm not in panel legal aid council, but my name has been shown as a legal aid council, my lord. Actually, I'm not in panel of the legal aid council. Madam.
You are.
I'm in the list of amicus curiae. Madam.
Lordship, for life and death, Lordship, there is a panelist, Lordship, and in panelist, his name was there.
Amicus.
So,
Amicus.
Lordship, amicus. Yes. So, and this instant is also life imprisonment, Lordship.
Yeah.
So, therefore, Lordship.
Only that there's
designated as amicus.
two set of the list, one is amicus and another is legal.
Amicus for what?
Amicus for life imprisonment.
No, appellant.
My lord, yes, my lord.
This
appellant accused, my lord.
Promotion could not be. Informant could not be.
This is a POCSO case. POCSO. All legal aid councils are amicus, but all amicus are not legal aid councils. Is it true? Think about it. Logical reasoning. But line of distinction is blurred.
Item number 10.
Lordship, in this matter, Lakshmi is appearing and she is out of business for medical treatment, Lordship. So this matter may be taken up next week, Lordship.
It's come up for the IA or?
And I was informed, Lordship. I am informed, Lordship. The paper we received paperbook or yesterday only, Lordship.
What did you say?
Paperbook is ready.
Yes, Lordship.
Where's the paper book? It's ready. Where is your prayer? What is your
Lordship, this matter may be taken up next week, Lordship, since El Hage is appearing in Lordship and she is out of business for medical ground, Lordship.
Prosecution, for the prosecution.
Yes.
You are PP. If
yes, even the
Lordship,
even
if the
Lordship, difficulty is even brief is not with me, Lordship.
Huh?
Brief is not with me, Lordship.
What is listed for what today? I think
for orders, Lordship. In orders.
Okay, then we'll next week. On the ground that engaged additional PP, additional PP is indisposed. Mr. L. Public prosecutor press for listing of the matter after a week. Mr.
M. Kambo. M.
Kambo, learned counsel for the appellant is present. List the matter. Prayer of the learned public prosecutor is accepted. List matter after a week.
Item number 11.
Lordship, item number 11 is also arising of same affair, Lordship.
Connected.
Connected, Lordship.
Paperbook is ready.
Paperbook is ready. We have already received. We have received the paper.
Okay, you change the name.
My lord, in that case, my lord, matter may be fixed on Tuesday, my lord, for hearing, my lord.
Next week, huh?
Next week, my lord, on Tuesday, my lord.
In place of Kambo,
M. Ratan.
same order.
Deeply obliged.
Item number 14 and 15.
My lord, in item 15, we are filing our affidavit today, my lord.
My lord, sir.
What is this?
My lord, this was very limited prayer.
Petitioner in person.
Yes, my lord, sir.
Okay.
So if they're filing the
Mr.
Yes.
P. Obin, petitioner in person.
My lord.
As prayed for by Mr. N. Ratan, additional advocate, that this matter will be listed after 3 weeks.
Yes, ma'am. And my lord,
respondents may file their respective affidavits. All of them.
Yes.
So we are filing 1 to 2 entry.
You have filed.
No, we are not filing.
And
yes,
Titatak for the implementers.
you are filing, huh?
Titatak.
You are filing affidavit.
In the IA.
In the IA.
IA is for what?
For the implementers.
Huh?
For the implement.
They wanted to implement in my PIL as a party, my lords. I was on the last occasion, my lord, I was saying that need not be an order, but if I have any documents to assist my lords, they may bring it. So this is what.
Intervener.
Yes, my lords.
You have an objection?
My lords, I am not having an objection to their implement, my lords. But the thing is, my lord, all of us are on the same page, my lord.
Huh?
All of us, even the implement applicants, are also in the same page.
What public interest here? What is the public interest? Public injury?
My lord, here what happens is, my lord, my lord knows that under the interpretations of the all tribes and also the NCST's directions and also the tribal affairs ministries and ORIGIs, my lord. And subsequently, my lord, the government of Arunachal has passed an order, my lord, for issuance of the ST certificates to the Yobin communities, my lord. Now, my lord, we have been the certificates has been issued. We have been availing benefits as a member of the scheduled tribes of the state of Arunachal, my lord. Now, what happened, my lord? There was always a confusion, my lord, because our name in the presidential order has not been specifically mentioned, my lord. So this created a confusion within certain departments, my lord. Like, for example, my lord, few students, my lord, they wanted to go for the state civil services. They passed this.
Mentioned in the presidential.
It is, but my lord, the interpretation is already come, my lord, by the NCST, also tribal affairs, also, my lord. It is all tribes intended, my lord, any indigenous tribe of the state of Arunachal, my lord. So the Yobins are the indigenous tribe of the state of Arunachal. There's no denial to that.
There.
Yes, my lords.
Covered.
Yes, my lords. So, but the confusion was that, my lord, some certain departments, my lord, when they go and check the list, my lord. So that is a confusion. So what our prayer was very simple, my lord. We are not asking, of course, my lords cannot have the power and
dispose of the IA.
let the IA be disposed of, my lords. Yes,
we'll allow them as an intervener.
Lordship, there's a new discovery in this case. Through RTI, it has been revealed that after the filing of this PIL, in the pending disposal of the case, they have held the issuance of the ST certificate to the Yobin community.
What?
They have the state government direction given by the Sejata. They have hold the issuance of the
First, you have to be allowed to be either as a party respondent or an intervener. Then you make your submission. Cannot have an audience on you unless. We're disposing of the IA.
My lords.
Mr. P. Tatak.
Let them have their say. Yeah.
Learned counsel for the applicant. And also had Mr. P. Obit, counsel for learned petitioner in person, public. Opposite party. Number one, comma, Mr. That earlier one will be in the writ petition. This is IA. And Mr. N. Ratan Lan, Additional Advocate General for the State of Arunachal Pradesh, comma, and Anju for Union of India, Waigao. Then the council appearing on behalf of Mr. M. Katulan, DSGI, and MS and Anju. Landed Council for APPSC.
Opposite party number 9.
Mr. Decision application. Seeking implement. Seeking implement in the connected PIL number 10 of 2020, 26.
25, my lord.
25 as intervener. List of the connected PL number so and so, PL 10 of 26 or 25?
That's the 2025, my lord, the PIL. The IA is 26, my lord.
Okay. Has been filed by the opposite party. Number 1, seeking protection and enforcement of their right, particularly seeking direction for recognition of the scheduled tribes, issuance of scheduled tribe certificate to the Yobin tribe in the state of Arunachal Pradesh. List of the next applicant claims to have knowledge and involvement in issues affecting the Yobin community. And would assist the court in determination of the matter. Therefore, phrase for implement as intervener. List of next having considered that the petitioner and that the applicant would be a necessary party to intervene in the matter, as the grievance raised in the PL is in respect of the status of scheduled tribe of the Yobin community, and considering that the parties had no objection for allowing the applicant as intervener, we deem it appropriate to allow this application. Accordingly, the applicant, namely so and so, is allowed to be participate as an intervener in the connected PL number 10 of 2025. Next para. The application instance allowed and disposed of. Then you write in the PL you file an amended cause title.
My lord, I'll do that.
So and so person to file an amended cause title, so and so. The registry to do the needful, registry to incorporate the name of so and so. You said in view of the order passed, in IS so and so, as intervener. List of, then you write that. List the matter after 3 weeks. In the meantime, you record their name on the prayer of Mr. Who else would like to file affidavit?
Will be filing.
All. All.
No, Your Lordship.
Will be filing.
On the prayer of Mr. List the matter so and so. In the meantime, as prayed for by the learned counsel for the respondents. No, as prayed for, respondents are directed to file their respective affidavit in opposition.
May I pray for 25th August, my lord? May I pray for 25th of August, subject to my lord's 25th August, my lord.
List.
Much obliged.
Item number 17.
Short. 7. After 5 minutes.
Number 17.
My lordship, in this present case, your lordship, in earlier.
I cannot take it up.
17. Your lordship has appeared as a counsel.
Yes.
Really?
List the matter before The appropriate bench.
Sorry, case nahi laga bolo.
Without one of us, my name, huh? Cannot take it up.
Item number 18 and 19.
My lord, item number 19 be taken up first because it's
Then, Lordship, the accused persons 3 were arrested and charge sheet was filed. Page 4. Charges as per the charge sheet was to be 302, 201, 120B, oblique 34 IPC. And photograph statements, rough sketch map, seizure list, Zima inquest report, copies of heading taking and PM report and FSL forwarding were enclosed. Later on, Lordship, the FSL report came and supplementary charge sheet was also filed. This is also in the records. That is at page 26. The supplementary charge sheet was filed to bring on record the FSL report, which was of a DVR and router of the CCTV, probably. This is at page 26 onwards, but nothing came out of it because that DVR could not be read with the available tools in the laboratory, and also that the laboratory does not undertake examination of exhibit RTQ1, that is the rotor. So even though the supplementary charge sheet was filed, there was no consequence for the prosecution. Then, Lordship, page 29 is the charge. As against the accused number 1, who is the appellant in this criminal appeal 11. Charges were framed under 120B IPC, 302 IPC, and 201 IPC. As against the second accused also, same.
Yeah, conspiracy is there.
Yes, conspiracy. Then as against the third accused, 212 IPC was framed, but of course he was acquitted.
212.
Yes.
There are only 2 accused, right?
Now there are only 2 accused, two appellants.
Someone expired.
Lordship?
No, someone expired.
No. There were 3 accused. 1 was acquitted. The third one.
Three accused face trial.
Yes.
And 2 were convicted. And
Yes.
One
yes. Well, the last one was only for offense of harboring.
212.
Yes.
Yes.
Then, Lordship, the seizures. Sorry, before that, Lordship, the inquest report is at page 32. Apparent cause of death as per the as per inquest report at page 33 due to severe head injury. And the weapon allegedly used, according to that, was seemingly a 12-volt UPS battery. Then seizure was done. Description of the seizure is seizure list is page 34. Spectacles, sling bag, car keys, UPS battery found on the head of the deceased, dagger, oblique machete, and mobile phone. All these things belonging to the deceased, except for the allegedly, except for the UPS, which was battery, which was from the bank itself, and the dagger and oblique machete allegedly belonging to the accused persons, convicts. Then Lordship, as part of prosecution, there was also a recovery made, which is at page 35. The recovery items were recovered from, this is at page 35. Recovered items were from a field area, Tengabari field area, Namsing, at Pasigat, near POPS Pasigat. The description of the seized articles during the recovery was a 15-inch monitor, stabilizer, DVR box, and router. This is allegedly recovered on a disclosure statement made by the accused number 2. Your Lordship will recall, as per the supplementary charge sheet, that DVR box and the router were sent for FSL, which did not give any findings. Then Lordship, the post-mortem report, page 39. Post-mortem was done on 8/2/2018. That is on the next day of the incident at 9:21 a.m. As per the post-mortem report, the condition of the subject, head, face, and neck tilt to wounds right side, left elbow slightly rotated, medically, left knee joint semi-flex, rigor mortis present all over the body, post-mortem staining present on the back of the trunk, gluteal and back of thigh regions. Then the wounds were described as cavity, deep lacerated wounds on mid-frontal region of the scalp, horizontally 6:1 cm with protrusion of brain and brain matters with blood and blood clot present. Number 2, cavity, deep lacerated wounds on central parental region of scalp runs horizontally 5 cm into 0.8 cm with blood and blood clot present. Cavity, deep lacerated wounds on mid occipital region of scalp.
Mostly head injuries.
Head injuries.
Yes, head injuries.
Yes, the findings were that because of the head injury caused, the brain and brain matter also was it came out. Yes, and Lordship, the detailed injury is given at page 41. Fractured mid-frontal, central, and parietal and mid-occipital regions of scalp and bones, respectively. Crushed injury to head and face, leading to laceration of brain, protrusion of brain and brain matters with blood and blood clot. So basically, on the top portion, there was a fracture also, because of which the brain matters also came out. Then the cause of opinion of the doctor is cause of death is due to injury to the vital organ, that is the brain. The Lordship, the sketch map of the PO is at page 54. This is a bank, APRB bank.
Rural bank.
Yes, Arunachal Pradesh Rural Bank. And it is just beside the road. And the PO is shown to be right in the middle. Then Lordship, the FSL reports, this I may not refer because there is nothing there that is helping the prosecution also. Then Lordship, the depositions. PW1 at page 63 is the wife of the deceased. On oath, she says, I know the accused who's standing on left side by face, but I have not seen those two other accused persons. On the day of the incident in the morning, my late husband went for his office at around 11 a.m. He came back to the house and after having some snacks, told me that he's going to Pasighat for some official work. Thereafter, I don't know when he came to his office in the evening. He did not return home, so I called him in his mobile, but he did not respond. So I called one of the colleagues, Mrs. Tokmem Ratan. She informed me that she left the officer early today, as she doesn't know whether my late husband, as such, she doesn't know whether my late husband was in the office or not, or therefore I called another colleague, and Anna Perme, who also informed me that she also left the office early, but as her house was near the office, I asked her to find out whether my husband was present in the office or not. While I was waiting, one person came and asked to accompany him to the bank. Accordingly, I went and found the car of my husband outside the bank. Many people were present in the office, but I was not allowed to go inside. Sometime later, one unknown person informed me that my husband is no more, as he is dead. So I became unconscious, and when I realized, I was at my quarter. I was asked by someone to put a signature on a paper, which was the FIR against unknown person. P Exhibit 1 is the FIR, P Exhibit 1A is my signature. After 20 days, I was informed by the IO that 3 persons were arrested in connection with this case. I went to the PS and saw 3 of the accused persons standing on the dock. Then from the defense side, cross was declined. Here, Lordship, even though she says that I know the accused person who's standing on my left by face, but I have not seen those 2 other accused persons. It seems from the last line that she went to the PS and saw the accused person standing on the dock. So it seems from here, I think it can be inferred that she saw the accused person after they were arrested.
Yes.
So no prior no prior knowledge about them. Then page 64 is
PW2.
yes, PW2. He is the bank manager.
Right.
The deceased was an assistant bank manager. He says in his deposition or not, I know the accused Subhas Mandal, but I don't know the other 2 accused persons. I know him as he was running a shop near our bank. On the day of the incident, I did not attend the office as I decided to do paperwork on my rented house. I informed my plan to do official work to the deceased one day before the incident, and I asked him to look after the office. At around 7 p.m., I was informed by Tokmem that the car of the deceased is outside the bank and the door was kept open without the light being open. So I rushed to the office. On reaching the office, I was stopped by the police informing me that the dead body of the deceased is lying inside the office. Later, I was called to identify the dead body, and accordingly I did. As suggested by my office staff, I also lodged a FIR against unknown person. Police has recorded my statement. Later on, I got information that 3 accused persons who were alleged to have killed my said staff was arrested and lodged in PS Pasighat. P Exhibit 2 is the signature on the Caesar memo. I saw the dead body when I was called for identification. The deceased was assaulted with a UPS battery on the back side of the head of the deceased. Here also cross decline. Then PW3, the next page, is a colleague
whom allegedly the wife of the deceased, that is PW1, called. The second person who was called on the phone. On note, she says, I know accused Subhas Mandal, but I don't know the other two accused person. I know him as he was running a shop near our bank. On the day of the incident, I was asked by the deceased to look after the bank as he was leaving for Pasighat to collect cash. At around 1 p.m., he returned from Pasighat and handed over the cash to me. After counting the same, I handed over the cash to the deceased. The total amount I counted was around 12 lakhs. At around 2 p.m., I took permission and left the bank for the day. At around 7 p.m., the wife of the deceased called me and told me that the deceased did not return home. On having received the message, I sent one of my friends to find out if she was still working or not, as I was having my dinner. I was informed later that the car of the deceased is outside the bank and the door was open without the light being open. When I reached the bank, there were many people and I found the wife of the deceased is already present. I could learn from the people that unknown persons have killed the deceased. I saw the dead body of the deceased and was full of blood. Later, I came to know that the accused persons standing on the dock were arrested in this connection. Here also cross decline. Then PW4. He is a customer. He says that I know the person standing on my left, Haradan. Haradan is the accused number 1. And right, Sukumar is the accused number 3. But I don't know the other person standing in the middle. These two persons were running a shop at Mabo. On the day of the incident, I went to the bank to deposit official money amounting to rupees 4,20,000 from the office of ADC Mabo. I don't remember the time I saw the deceased and two other lady staffs. There were some customers. After depositing the same amount, I went back to my office. Here also, decline, crosses decline. Then PW5 is the colleague of the deceased person and also the first person whom the wife of the accused called. On oath, she says, I know the person standing on my left, that is the accused number 1, but I don't know the other two accused persons. I am one of the bank. I'm one of the staff of APRB Bank. On the day of the incident, deceased left for Pasighat and came back around 1 p.m. In the office. I saw one of my staff fine counting the cash amount along with the deceased. I came to know from that the total amount was 12 lakhs. Thereafter, the lady staff left the office around 2 p.m. I also, after doing my work, left for the office at around 3:40 p.m. after taking permission from the deceased. In the evening, around 7:30, deceased's wife called me and asked me if I'm still in the office and or not, because her husband, who was killed, has not come back. I accordingly went to see if the said husband is still working in the office or not, but I found no light in the office and also found that the door is not locked. The car of the deceased still parked in the same place. Thereafter, my husband went to call deceased's wife. After arrival of the police, I came to know about the incident. I have not seen the dead body. Public cannot know the arrival of cash amount in the bank. Here also cross decline. Then PW6 is the doctor who had conducted a postmortem. He says, according to my findings, the cause of death was due to injuries on the vital organ, that is the brain, and it was produced by blunt, moderately and heavy object process. The nature of injuries could be a case of homicidal or not, cannot be ruled out. This is neither here nor there. Then this cross was also declined against this witness. Then the next PW7, this is the same person who was at PW2. He is also a seizure witness. So he's as PW7 is deposing as a seizure witness. There are for the seizure, this witness was examined twice because it appears that the
material exhibits were not present or were not in the court on that day. The first one is on 17 June 2019, which is at page 69. Here he has signed a seizure memo. He has exhibited the seizure memo regarding the mobile spectacles, key of the car, small dagger, and UPS material. Then on the next date, that is on 25th of February 2020, he was examined again. Here he has said that the police have seized one UPS battery, one bag, mobile handset, vehicle keys, and there was blood stain contained in the UPS battery and dagger. Even in the bag seized by the police, there was blood stain. In fact, there was blood all over the PO. The material exhibit marked as M Exhibit 2, the dagger shown to me in the court, is the same dagger which was seized by the police from our bank on 7/2/2018. The material exhibit marked as M Exhibit 3, UPS battery, shown to me in the court today, is the same UPS battery which was seized by the police from our bank on 7/2/2018. Then in the cross at page 71, he says, please not written on behalf of whom the cross has been made. But there is a cross here apparently, page 71. It is a fact that my statement was recorded by the police, where I have stated that there was a blood stain on the PO and on the seized materials. It is a fact that the UPS battery used to have numbers, but I did not notice the number of the seized UPS material Exhibit 3, nor the police had informed me. It is not a fact that there was a blood stain on the spot and the seized. It is not a fact that there was no blood stain on the spot and the seized materials M Exhibit 2 and M Exhibit 3. And on the it is not a fact that M Exhibit 2 and 3 shown to me in the court today are not the same materials seized by the police from the spot on that day. Then page 72.
The prosecution case is that he was alone in the bank with the 12 lakhs cash.
Yes.
Like that.
On that day, 12 lakhs cash was deposited. Let me just say the story in a very short way. The prosecution case, though they have not said anything they have not proved anything in the through their witnesses. But as per the charge sheet,
complete the deposition.
Yeah, complete the deposition. Sorry.
Okay. Page 72 is Rupam Deka. He is PW8 and he is the brother-in-law of the brother of the accused.
Relative.
One of the accused, yes. He says or not, he was declared hostile. I know the person, I know those.
One.
Yes. A1 and A3 are brothers.
Okay.
Their brother married this witness's sister.
A1 and A3.
A1 and A3 are brothers.
Acquitted.
Yes, acquitted.
They are brothers.
A3 is my brother.
No, both are brothers.
A3 is my brother.
Don't know. Sukumar or
Married to the sister of the A1 and A2.
Sukumar comes sister, no? He says or not, I know these two persons who are standing on the dock as Kokon Mandal, and the other one is not known by me, but he is the own brother of Kokon Mandal. Kokon Mandal is Sukumar, the accused number 3, is known as Kokon Mandal. I don't, the other one is not known to me by name, but he is own brother of Kokon Mandal. I don't not the third person by name and face. I went to Mebo from Janai as suggested by my brother-in-law to pick up the wife and children of his brother. I don't know the case, but we have sent the said wife and children next day from Janai to Kuch Bihar. It was me who brought the wife and children from Mebo to Janai, and apart from this, I don't know anything about the case details. At this stage, PP has prayed the court to allow the
to allow him to be declared to be hostile. A prayer was allowed, then cross was by PP at page 73. I was at Drayang village when my brother-in-law called me and asked me to pick up the wife and children of his brother from Mebo. I accordingly hired a Tata Magic vehicle and went to Mebo. I wanted the said driver to wait for some time, but he left without informing me. After that, the Tata Magic left and I dropped the said wife and the children in the motorcycle of my said brother-in-law. It is not a fact that his elder sister told me that the family members may not return again to Arunachal Pradesh. It is a fact that it is not a fact that I told the police that the brother of my brother-in-law, while trying to rob the bank, had killed the cashier of the bank. It is a fact that after release from the jail, I had confirmed that the brother, Subhas Mandal, of my brother-in-law and others, has killed the cashier of the rural bank of Mebo. Then PW9 is also the seizure witness. He has also deposed twice. Once is on 9th of August 2019. This is regarding for exhibiting the seizure memo. Then on the next page is the second time that he was examined on 25th of February 2020. Here he is exhibited, identified the materials, that is the UPS battery and those things which were recovered from the bank. May I read, my lord, page 75. He has said on note 9/8/2019, I appeared before this court to give my evidence in connection with the case, but since the material evidence were not available in the court on that day, my evidence could not be completed. So today I have been summoned to give remaining evidence. The IO of the case seized some materials from the Arunachal Pradesh Rural Bank Mebo branch in connection with the present case. And as a magistrate, I was present on 7/2/2018 when the police seized some materials from the PO. The police have seized one UPS battery, one bag, mobile handset, one vehicle keys, and a dagger. The dead body of the victim was found lying on the ground, and the UPS battery used as a weapon of offense on the head of the deceased. There was blood stain contained in the UPS battery, as it was apparently seen as a weapon of offense. There was blood stain all over the PO. The material exhibit marked as MM Exhibit 2, the dagger shown to me in the court today is the same dagger which was seized by the police from the bank on 7/2/2018. The material exhibit M Exhibit 3, UPS battery shown to me in the court today seems to be the same UPS battery which was seized by the police from the bank on 7/2/2018. In cross, he says, I do not remember whether there was blood stain in the seized dagger or not, but there was blood all over the floor of the PO. It is a fact that I did not properly notice whether there was blood stain on UPS or not, but UPS battery M Exhibit 3 was lying on top of the head of the deceased. When I entered the bank on being called, the police and some persons were already present there. It is a fact that I am not the first person who see the dead body of deceased. It is a fact that it is not a fact that I'm giving false statement before this court that the UPS battery was found on the head of the deceased. Then PW10 is a seizure witness of the things that were discovered, that were recovered as per the disclosure statement of accused number 2. This is one Kennedy Perme. On oath, he says, some years back when I was coming from my field, one SI B Pite stopped me near the residence of accused Ramesh Yadav. And when I was since I was at that time ASM of Namsing village, I was made to put signature as a seizure witness. At that time, I was shown a monitor, stabilizer, DVR, and router in the police vehicle. And even Mr. Ramesh Yadav was found inside the vehicle, police vehicle. I was told by the police that those materials were recovered from the pawn of Sri Yamut Parme, the GB. P Exhibit 3 is a seizure list, and P Exhibit 3A is my signature on it. M Exhibit 1 are the seized materials comprising of monitor, stabilizer, DVR box, and router. Then cross was declined by the counsel for the accused number 3. So far as accused number 1 and 2 were concerned, the defense counsels were absent. Then page 78, he is also one of the witness of the same. There were 3 witnesses. He's the second one. On note, he says, some years back, I was picked up by SIB PITE to witness the recovery made from my pawn at Tengabari belonging to Sri Yamut Parme GB. I saw that one monitor, stabilizer, DVR box, and a router were taken out from the pawn. I do not know who had kept those materials in the pawn. P Exhibit 3 is a seizure, and P Exhibit 3B is the signature. M Exhibit 1 is a seized materials comprising of monitor, stabilizer, DVR box, and router. Then the in the cross, for this I will not read out because this is so far as accused number 3 is concerned. The counsel again was absent for the accused number 1. Then the next page, PW 12, is the last seizure witness of the recoveries allegedly made from the pawn. On note, he says, some years back, I was picked up by SIB PITE to be a witness of seized materials near the pawn of Sri Yamut Parme. I found that accused Ramesh Yadav was already standing. On being asked by police and even on my plea to disclose about the missing materials, Ramesh showed towards a pawn. From there, police recovered some machines in my presence, and I was made one of the witnesses. P Exhibit 3 is the seizure list, and P Exhibit 3C is my signature. M Exhibit 1 are the seized materials comprising of monitor, stabilizer, DVR box, and router. Then again, the counsel of the accused persons were absent. Then PW 13 is a witness who had given his signature in the inquest report. This is Kenter Koyu. On oath, he says, on getting information about the murder incident of the deceased, I also went to the bank, and on being permitted by the police, I entered the bank and saw the dead body of the deceased was lying on the floor of the bank near the cashier's counter, and UPS battery over his head. The neck of the accused deceased was found totally bent due to pressure of the UPS battery over his head. There was blood, full of blood all over the floor. Later on, the dead body of the deceased was taken to Mebo Hospital where the inquest was conducted, and on being asked, I put signature on the inquest report. The inquest report is was exhibited as P Exhibit 4, and P Exhibit 4 is his signature. Then P Exhibit 5 is the photographs, which was also exhibited. Then there is a cross at page 81. In the cross, he says, I put a signature on P Exhibit 4A at Mebo Hospital. P Exhibit 4A is his signature on the inquest report. It is a fact that the police has not read out the content of the inquest report to me, but just inquired if any person related to the deceased on the spot. So I put the signature as known person to the deceased. I do not know who took the photographs of the deceased. This is the first time that I have been shown P Exhibit 5 series in the court. Then PW 14, I may not read this out, Lordship, because it's not necessary. He simply says, I've been issued someone and I know nothing about the case. Then PW 15 is the brother of the deceased. Page
Brother of the deceased.
Brother of the deceased. He says, I know all the accused persons standing on the dock. They are Subhas Mandal, Ramesh Yadav, and I have forgotten the other accused person, although I could recognize his face, pointing towards accused Sukumar Mandal. On the night of 7 February 2018 at about 10 p.m., while I was at Nirjuli, I received a phone call from my brother, Bomar Nyori, that the deceased Bomar Nyori has been found murdered at Mebo. Then I immediately left. Then I immediately left for Merbo and reached Merbo the next morning, that is on 8/2/2018. I straight away went to medical at Merbo and saw the dead body of the deceased Bomga Nyori. His head was found crushed. After conducting post-mortem over the dead body of the deceased, the body was handed over to us, whom we took to our village for performing last rite of the deceased. Later on, after many days had passed, we received information that the culprit in the murder case has been arrested. Then we went to see the murderer of my deceased elder brother in the police station. On being asked out of curiosity as to why they had killed my elder brother, the accused Subhas Mandal and Ramesh Yadav confessed before us that they had killed my deceased brother for money. He is also one of the witness in the inquest report, so he exhibited his signature. Then in the cross, this is a cross on behalf of the accused number 2. This I may not read. Then page 85 is the officer in charge of the Mebo police station. PW16. He was not examined as under 161 earlier. On note, he says, I know all the accused persons standing on the dock as I have seen them earlier, but I do not remember the names. During the year 2018, I was working as officer in charge of police station Pasigat. At that time of the incident of this case on 7/2/2018, I was on leave. However, the incident of the instant case took place the same evening when I joined ALO, and I was recalled from my leave by SP on telephone. So I rejoined my duty immediately on the next day, that is 8/2/2018. When I rejoined my duty, I found the case was already registered by in charge OC Pasigat, SIT Booker, and SI B Pied was endorsed as the IO to investigate the case. The IO of the case, DSP T Makcha, SIT Booker, and other police teams were already present there on duty at Mebo. Then I also proceeded to Mebo and visited the PO. We were looking for the suspects. As the incident took place at around 7 p.m. on the previous night, I also inquired the neighbors, including the shop nearby. Even I inquired the main accused, Subhas Mandal, who was running a small shop opposite nearby the Arunachal Rural Bank Mebo from his shop. The entrance of the gate of the bank could be easily seen. On being asked, he told me that he did not see any activities in the previous evening as it was dark. At that time, I did not know he was the main accused. On the next day, also, we went to the PO looking for suspects and came to know that Subhas Mandal fled away from Mebo. We came to know that his elder brother had married a girl from Jonai. When we went to Jonai, we came to know that he had already left for his hometown. Then a team constituted to proceed to his hometown at Kuch Bihar, West Bengal. The accused Subhas Mandal was arrested from railway station Kuch Bihar when he was trying to leave for Gujarat. After arrest, the accused was brought back to Pasigat. In interrogation, accused Subhas Mandal disclosed the name of his partner Ramesh Yadav, who was involved in the offense. Then accused Ramesh Yadav was picked up from Namsing and brought back to Pasigat. On examination, he disclosed that the electronic gadgets like CCTV camera, desktop, and DBR of the bank were taken by him on a gunny bag loaded in his private car and took it to Tengabari area in Namsing and dropped it in the water pond. He led us to the pond. And we engaged a local man who dived inside the pond and brought out those electronic gadgets from the pond. And the same was seized on the spot, and a DBR was sent to FSL for recovery CCTV footage. Later on, IO informed me that during investigation, the accused Subhas Mandal admitted his guilt of commission of alleged offense and stated that he and accused Ramesh Yadav planned to loot money from the bank. On the incident that the accused Ramesh Yadav came from Pasigat, Ramesh Yadav was engaged to watch people within the bank compound while he entered inside the bank and requested the deceased to update his bank account. And in the process, when the deceased was busy taking something from his drawer, the accused Subhas Mandal hit the deceased on the backside of his head with iron rod, due to which the deceased fell on the ground. When the deceased fell on the ground, the accused lifted a battery lying nearby and smashed on the head of the deceased, due to which the deceased died on the spot. After killing the deceased, the accused Subhas Mandal told Ramesh Yadav to pack all the electronic gadgets, and accordingly Ramesh Yadav packed all the electronic gadgets into a gunny bag and threw it in the pond. Accused Subhas Mandal also told me that after the incident, he informed his elder brother, Sukumar Mandal, who was staying at drawing, and later on, after 2-3 days, his elder brother Sukumar Mandal took all the members of the family to Jonai. And even I also had talked with accused Subhas Mandal. At that time, he told me that he was at Silapatar for business purpose. P Exhibit 5 shown to me in the court today is the photographs of the dead body of the deceased lying on the spot with battery over his head. His place of occurrence for which I can identify. However, when I saw the dead body was already removed from the PO and only the battery was lying on the spot. P Exhibit 5C is the photographs of the pond from where the seized materials were recovered on being led by accused Ramesh Yadav. P Exhibit 5D and E are photographs showing the electronic gadget materials recovered from the pond led by accused Ramesh Yadav. M Exhibit 1 is a seized materials comprising of monitor, stabilizer, DVR and router recovered from the pond led by Ramesh Yadav, to which I can identify. PM Exhibit 3 is the UPS recovered from the PO, to which I can identify. Then crossed by counsel of the accused number 1. It is true that my name is nowhere reflected in the charge sheet. It is true that the IO of the case would be the best person to know everything about the case, as he has investigated the case from the beginning. It is correct that I am not the seizure witness in the case. I rejoined as OC of Pasigat PS on the next day of the incident itself. It is true that I have guided the IO of the case in the instant investigation. It is true that the charge sheet was also filed under my guidance. We have charge sheeted on the basis of statement of the accused themselves. Therefore, I do not think we have charge sheeted wrongly. Then, Lordship, PW 17 is the IO of the case. Page 89. Or not, he says, I know all the accused persons standing on the dock. They are Subhas Mandal, Ramesh Yadav, and Sukumar Mandal. After the incident, on registration of FIR, I was endorsed by the officer in charge, Sri T. Booker, to investigate into the case. During the investigation, complainant / witnesses were examined and their statements recorded, PO visited and photographs taken. Inquest / PME was conducted over the dead body of the deceased, and the dead body was handed over to the relatives of the PME. Weapon of offense, that is UPS battery, iron rod and knife were seized and kept in PS Malkana. 4 accused persons, namely Sri Ogin Ratan, Ramesh Yadav, Subhas Mandal and Sukumar were interrogated. The seized materials, DVR, CCTV monitor, camera of APR Bank were recovered from a pond at Tengabari of Namsing. On being led by one of the co-accused, namely Sri Ramesh Yadav, the DVR CCTV was recovered and forwarded to CPSL Calcutta for recovery of the CCTV footage of the day of the incident. During investigation, it was revealed that the statement of accused Subhas Mandal and Ramesh Yadav that they had planned to rob APRB Mehboob branch sometime in October 2017 and had made an attempt in the earlier occasion also. But due to sudden appearance of a customer, the plan was skipped. On 7/2/2018, Sri Subhas Mandal is supposed to have called Sri Ramesh Yadav, who was at Pasigat, at the time, to come to Merbo to effect the plan. After the arrival of Ramesh Yadav at Merbo, accused Subhas Mandal engaged him as an observer to watch the movement of the police near the bank and himself went inside the bank to execute the plan. On arrival, it was found that the deceased, leaving the bank as he was well acquainted with him, requested him to deliver him his passbook. The deceased accepted his request and he was in the process of sorting out the passbook by bending over the table. Seeing the opportunity, the accused hit the deceased with an iron rod at the back of the head, which he had brought along with him to be used as a weapon of the offense. The blow was so fatal that the deceased fell on the floor and was gasping for air. Seeing him still alive, he picked up a UPS battery which was lying nearby and smashed the head of the deceased with it. Thereafter, he checked the pocket of the deceased where he found the wallet of the deceased.
Okay, madam.
Continue at 2. We'll continue at 2.
Yes.
And we're almost through the evidence. And then
Yes.
we'll complete it.
Yes.
And start at 2 o'clock. And then
Yes.
then make those submissions.
What important?
Yes, ma'am.
May I please, Your Lordship? My Lord, we were on page 40, the statement of the IO. May I continue, my Lord? On 7/2/2018, no, sorry, this is page 90. Looks because of the thing, it looks like 40. Yes. Page 90. On 7/2/2018, Sri Subhas Mandal is supposed to have called Sri Ramesh Yadav, who was at Pasighat at that time, to come to Merbo to effect the plan. After the arrival of Sri Ramesh Yadav at Merbo, accused Subhas Mandal engaged himself as an observer to watch the movement of the public near the bank and himself went inside the bank to execute the plan. On his arrival, it was found that the deceased was leaving the bank as he was well acquainted with him, requested him to deliver his passbook. The deceased accepted his request and he was in the process sorting the passbook by bending over the table. Seeing the opportunity, the accused hit the deceased with an iron rod at the back of the head, which he had brought along with him to be used as a weapon of the offense. The blow was so fatal that the deceased fell down on the floor and was gasping for air. Seeing him alive, he picked up a UPS battery which was lying nearby and smashed the head of the deceased with him. Thereafter, he checked the pocket of the deceased where he found the wallet of the deceased and took it along with the key of the locker and tried to open the locker. But as he was in a hurry and in fear, he could not open it. When he opened the bank door to lead his accomplice, Sri Ramesh Yadav, who was standing guard at the bank door. As he was unable to open the locker, he decided to leave the place, and before leaving, he went into the bathroom, / toilet, washed off the blood stain on his body, and threw the wallet of the deceased in a bucket kept in the bathroom/toilet. Thereafter, he went to the room of the BM of APRB where the DVR of the CCTV camera was installed. DVR and other accessories like router, stabilizer, and desktop and wrapped it in a carton and handed it over to the co-accused Ramesh Yadav to go through/dump in a place from where it could be retrieved. Accused Ramesh Yadav took the DVR and other accessories along with him in his car and threw them in the pond at Tengabari and the Namsing village. The act of accused Subhas Mandal and accused Ramesh Yadav amounts to pre-planned and cold-blood murder of the victim led Bomgay Nyori. Later on, the DVR of the CCTV camera and other accessories like router, stabilizer, and desktop were recovered from a water pond at Tengabari area in Namsing. However, the accused Subhas Mandal disclosed that the iron rod used for hitting the deceased was threw away at the general playground, Mebo, and so the same could not be recovered despite all efforts made to finding it. Moreover, when the accused disclosed about throwing of the iron rod, already more than 18 to 19 days had passed. In the PME report, Dr. T. Pertin, MOCHC, Mebo, has opined that the cause of the death is injury to the vital organ, that is brain. Moreover, the involvement of the alleged accused Sri Shiv Kumar cannot be ruled out in this case unless CCTV footage is retrieved, as the DVR has been sent to CFSL Kolkata. It was also found that the deceased Sukumar Mandal had harbored accused Subhas Mandal after the commission of the crime, and both of them managed to flee away from Mebo. P Exhibit 1 is the FIR. P Exhibit 1B is the signature of the OCPS Pasigat SIT Booker. P Exhibit 2A is the seizure memo prepared by me. P Exhibit 2A3 is my signature. By the seizure memo, one spectacle, broken, sling bag, black color, car key, Hyundai, UPS battery, dagger/machete, mobile phone. However, they are not seen in the court today. Probably it was released on Jimanama. P Exhibit P3 is another seizure memo prepared by me about the recovery of monitor, stabilizer, about P Exhibit P3 is another seizure memo prepared by me about the recovery of monitor, stabilizer, DVR, router, and P Exhibit 3D is my signature. P Exhibit 4 is the inquest over the dead body of the deceased prepared by me. P Exhibit 4C is my signature. P Exhibit 5, A, B, F, G, H, I are photographs of the dead body of the deceased lying on the spot. P Exhibit 5C and I are photographs of the pond from where the electronic items were recovered on being led by accused Ramesh Yadav. P Exhibit 5D and E are photographs of electronic items recovered from the pond. P Exhibit C is the handing over of the dead body of the deceased to one Ibom Nyori, and P Exhibit CB is my signature. P Exhibit 7 is a rough sketch map of the PO prepared by me. P Exhibit 7A is my signature. P Exhibit 8 is the Zima Nama of the article released to one Ibom Nyori. P Exhibit 8A is my signature. P Exhibit 9 is another Zima Nama for release of vehicle to one Margariba. P Exhibit 9A is my signature. P Exhibit 10 is the handing over of the dead body of the deceased for PME prepared by me. P Exhibit 10A is my signature. P Exhibit 11, taking over of the dead body of deceased after PME prepared by me. P Exhibit 11A is my signature. P Exhibit 12 is the forwarding of the seized material to OCPS Pasigat for examination. P Exhibit P12 is my signature. P Exhibit 13 is the forwarding of the accused arrested persons before the magistrate. P Exhibit 13A is my signature. Both the accused persons, namely Subhas Mandal and Sukumar Mandal, were arrested from Kuch Bihar by SIV Lawang. P Exhibit 14 is a charge sheet submitted by me. P Exhibit 14A is a signature of OC A Taki, which I can identify. He was OCPS Pasigat at that time and forwarded the charge sheet. P Exhibit 14B, C, D, E, F, G, and G are my signatures. P Exhibit 15 series containing 14 pages are the statements of witnesses and the accused persons recorded by me. After completion of the investigation on my part, I have submitted charge sheet against 3 accused persons, Subhas Mandal, Sukumar Mandal, and Ramesh Yadav. And as there was no prima facie case found against the alleged accused person, Obin Ratan, I prayed for his discharge. And since the FSL report was still awaited, I also kept open for further investigation and prayed for submission of supplementary charge sheet after completion of the investigation. Now I'm retired, so I do not know whether the incumbent has received the FSL report or not. On behalf of the accused number 1, the cross-examination is as follows. It is true that during the investigation, I did not find any concrete evidence or eye evidence to the incident. It is also true that I have filed charge sheet basing on the statements and recovery of the seized materials on being led and shown by one of accused Ramesh Yadav. It is also true that I have not sent the accused person for recording their confessional statement under section 164 CRPC. It is also true that during my investigation, I found that the accused Subhas Mandal and Ramesh Yadav had planned to commit robbery in the APRB Mabo, but there was no evidence to kill someone on their plan. It is also true that I had charge sheeted against the accused based on circumstantial evidence. It is also true that the charge sheet which I have prepared was under the guidance of OCPS Pasigat. It is not a fact that I have not found evidence as reflected in the charge sheet. It is also not a fact that I have charge sheeted the accused persons falsely on advice of the concerned SP and OCPS Pasigat. Then, Lordship, he was again re-examined at page 96, re-examination by PP. Although there is no documents on record which shows that SIV Lawang was part of the investigation team at that time, SP Pasigat himself was monitoring the investigation of this case, and I was investigating the case at PO at station being outpost in charge Mabo PS, whereas SIV Lawang was engaged to investigate outside the state to arrest the accused who fled the state. Then PW 18 is one SIK person. He was the IO who had submitted the supplementary charge sheet, which was the FSL report. He has mentioned that I'll just read from the second paragraph, if your lordship permits, because this is not that much relevant. During the investigation, the previous IO of the case had seized the following articles. Page number 97. SIK Pertin.
Okay. During the
during investigation.
previous IO?
Yes, during the second para.
Yeah.
During investigation, the previous IO of the case had seized the following articles with DVR box bearing model number DHDVR 2104H-V2 S/N dash TZA 4FP O20 WKN 18N and router bearing product number JG514 based on the disclosure statement made by one of the alleged accused, namely Ramesh Yadav, and sent to the director CSFL Gauhati for expert analysis with a prayer to retrieve the CCTV video footages. On receipt of the CFSL report, I have been endorsed to submit supplementary charge sheet. The CFSL report expert, namely L. Nato Singh, Assistant Director and Scientist, are opined in this report that the exhibit HDQ, that is DVR hard drive, could not be read with the available tools in the laboratory, as such data could not be retrieved. Further, he opined that the laboratory does not undertake the examination of the exhibit RTQ, that is the router. And he has exhibited the supplementary charge sheet as P Exhibit 16. P Exhibit 16 is a signature, and P Exhibit 16B is the signature of Inspector Otugao, OCPS Pasigat, to which I can identify, having worked with him for a long time. P Exhibit 17 is a forwarding report and exhibit by the Director CFSL Kamrup Assam. P Exhibit 18 is the FSL report with the details of parcels, exhibits received by them. M Exhibit 1A is the DVR, marked as DVRQ. M Exhibit 1B is the hard drive marked as HDQ1. M exhibit 1C is the rotor mark as RTQ1. Then the cross by the defense counsel. I learned defense counsel raised objection about to the filing of the charge sheet, supplementary charges after a long gap of 3 years. I have submitted the supplementary charge sheet P Exhibit 16 on being endorsed by OCPS Pasigat. I have not made any inquiry why this supplementary charge sheet could not submit at earlier date. The FSL report P Exhibit 18 is prepared on 14/9/2020 normally to collect forensic laboratory report from the date of preparing the report. It takes 2-3 days after receiving message from CFSL to collect the expert report. In murder cases, the time period for filing the charge sheet is 90 days. It is true that I have not investigated the case, but on record I could not find any order for further investigation of the case. This may not be so relevant, Lordship. Then, Lordship, page 99. This is the deposition of SIV Lawang, who is said to have arrested the accused from Kuch Bihar. PW 19. I know all the accused persons standing on the dock. On 7/9/2018, on the night of the incident, I was the NEDO, that is night duty officer at police station Pasigat at 21:15 hours. The then OC Inspector T. Booker informed me that a murder had taken place at APRB Mebo. As a night duty officer, I accompanied OC to Mebo. On reaching there, I saw one person lying in a pool of blood inside the APRB Mebo. Later on, I came to know he was the cashier of APRB. His name was Led Bomganyori. After some time, I returned back to Pasigat, leaving OC on the spot for my further duty. From the next day onwards, I took part actively in assisting the IO of the case. We regularly visited the PO, and one day we decided to check the rooms of Sri Subhas Mandal, the alleged accused. We grew suspicious as he had suddenly disappeared after the incident, whereas his shop is situated just opposite of APRB. While checking his room, we found that there was half-eaten food and untouched curry, and our suspicions grew. His phone was switched off. On 21/2/2018, I along with SI W. Mungre and Head Constable S. Kumar and Constable W. Diwan left for West Bengal in order to apprehend the accused. We reached Kuch Bihar in the evening on 22/2/2018 and had a meeting with SP Kuch Bihar, who promised to extend all possible help to help us. On 26/2/2018, with the help of West Bengal Police and Railway Police of New Kuch Bihar, we apprehended the alleged accused and along with his brother Subhas Mandal from the railway station ticket counter. On the same evening, I arrested them and produced them before the Honorable Court of CGM Kuch Bihar, praying for transit remand for 5 days. While interrogating the accused on the way, he revealed that he had murdered Led B. Nyori with the assistant of co-accused Sri Ramesh Yadav. Then I immediately called up the OC and requested him to apprehend the accused Ramesh Yadav, who was at the time in Namsing village. We reached Pasigat on 28/2/2018. I handed over the alleged accused with all the relevant documents to the IO of the case, SIB Pite. However, on the same day, I accompanied the IO of the case to recover the DVR box of APRB from a pawn situated at Tengabari, Namsing. Accused Ramesh Yadav disclosed the place and led us to the place where he concealed the DVR after the incident. On being shown by him, the IO took help of one local man who was expert in diving to search the DVR inside the pawn. After more than 1 hour, the person found a DVR and brought out from the pawn, which was seized by the IO. He also exhibited photographs, then a photograph of the knife, photograph of the pawn where the electric items were being recovered, then photographs of the electronic items recovered from the pawn. Then P Exhibit 19 is the arrest cum inspection memo of Subhas Mandal. P Exhibit 20 is the arrest cum inspection memo of the accused Sukumar Mandal. P Exhibit 21 is the prayer made before the CGM Coach Bihar for transit remand of the arrested accused Sukumar Mandal and Subhas Mandal. M Exhibit 1 are the seized materials comprising of monitor, stabilizer, DVR, and rotor recovered from the pawn led by Ramesh, accused Ramesh Yadav, to which I can identify. M Exhibit 3 is the UPS recovered from the PO, which I can identify. Then there is a cross by the Defense Counsel for Sukumar Mandal. As for the accused number 1, it is at page 101. Lordship, before that, I would also like to read out the cross on behalf of the Sukumar Mandal, because there is something about the railway tickets here. Page 100. Since 2014, I joined Arunachal Police Force in the rank of sub-inspector. It is a matter of fact that I had gone through the probation period at Pasigat. Till date, I have investigated 2 murder cases and charge sheeted. It is a matter of fact that during the training session, I have gone through the legal classes, which is mandatory. Yes, I know all the procedure of crime investigation. As the IO of the case was having health problem, the OCPS Pasigat verbally directed me to assist the IO of the case in arresting the accused and investigation of the case. I can say that some part.
This part is not here. You have.
It's not there, Lord. Page 100.
Page 101 is not there.
Oh.
Anyway, I think
in page 101, he has said that he could not seize any railway tickets from them.
Read it. You can read it.
Yes.
It's got actually page is blank. Probably
yes.
did not get printed.
In the second paragraph, I'm just going to read the second. According to my finding, accused Sukumar Mandal is directly involved in the murder case by helping Subhas Mandal in escaping. He knew that the accused Subhas Mandal has committed murder in Arunachal Pradesh. Accused Sukumar was arrested from railway station Kuch Bihar as they were about to purchase railway ticket only and not yet purchased. I could not seize any railway tickets from them. It is true that accused Sukumar, being as stated before me, he only accompanied Subhas Mandal to railway station, who was leaving for Bhopal. As Sukumar also stays at Mebo, he was found missing from Mebo, and accused Sukumar was found missing about at the same time. Later, they were found together in Kuch Bihar and arrested. That made me doubt that he is involved in harboring Subhas Mandal. I have arrested both Sukumar Mandal and Subhas Mandal from Kuch Bihar with the help of West Bengal Police. Then it is the defense by cross-examination on behalf of the accused number 1 and 2. While on the way from Kuch Bihar, the accused Subhas Mandal disclosed and stated before me that he had killed the cashier with the help of accused Ramesh Yadav. He admitted before me, in the presence of the witnesses, my colleagues, SI W. Mungre, on the basis of this disclosure statement, I immediately gave information to the OCPS Pasigat that the accused Ramesh Yadav is also involved in the murder of the cashier. So I requested him to arrest Ramesh Yadav. It is not a fact that I am giving false deposition before this court. Then, Lordship, this concludes the prosecution, the witnesses. Now, Lordship, as I wanted to point out in the beginning itself, the story of the prosecution as per the charge sheet is that they entered the bank when nobody was there. The statement made by the IO is itself the whole prosecution story, that they entered the bank when nobody was there. They approached the deceased person asking to renew the passbook or something of that sort. Then he was attacked from the back by an iron rod. Then thereafter, they tried to take money. Then after hitting with the iron rod, then when he fell down, he was not yet dead. So he was attacked with a battery, UPS battery. He died on the spot, and that is the story. Then thereafter, the DVR and everything was thrown in the pond. Later on, they were arrested, and on disclosure by Ramesh Yadav, those things were recovered. That is the prosecution story. Your Lordship has seen the witnesses' statements, depositions. Except for the statements made by the police, the IO, the OCPS, Pasigat, and the last PW which I have read out now, the person who had gone to Kuch Bihar to arrest PW 19, the person who had gone to Kuch Bihar to arrest both the accused persons, except for their statements, there is not one single evidence, not one single line that is connecting the accused persons to the case. There is one witness who might have connected, but that witness, PW8, that witness turned hostile. Now, after he turned hostile also, there is...
Who's related to?
Yes, who's related. If he had not turned hostile, or at least if his statement was proven by way of eliciting the statements from the IO, whether these statements were made or not, that also has not been done by the prosecution. If it had been done, then maybe it could have been proven that after the incident that they ran away.
That is just a circumstance.
Yes, yes, but
it was just a circumstance.
Yes, yes, but still that could have been one of the maybe the links. That is also not there. So the whole case, there is nothing. But your Lordship will find very interesting that in the 313 examination, the accused number 1 is said to have admitted everything. So therefore, it is essential to read his answer in the question number 1 of the 313 examination. May I read, Lordship? It starts from page 102.
Yes.
And continues in the next paper book. There are 2 paper books. The question was, PW1, Srimati Ibom Nyori, lodged an FIR, P Exhibit 1 against unknown person for killing her husband inside the rural bank, Mebo, and after 20 days on being informed by the IO, the 3 persons were arrested in connection with this case. She went to the PS and saw you. What do you have to say on this? His answer is, I would like to state that on 7/2/2018, accused Ramesh Yadav called me at 11:30 a.m. while I was in my shop at Mebo. He inquired about the whereabouts. He inquired me the whereabouts of the cashier late Bomga Nyori. My shop is located just opposite to the rural bank, and as on that day, the vehicle of late Bomga Nyori was not seen parked as it generally used to be. So I informed accused Ramesh Yadav that the cashier was not present in the bank on that day, and I do not know the whereabouts of the cashier. Then he suddenly told me that he has seen the vehicle of the deceased at Pasigat main market. He told me that the accused is going to rural bank at Pasigat and he will chase the deceased and call me back later on. He told me that the deceased is going with a black leather bag in rural bank Pasigat. Generally, if the check is deposited in the bank at Mebo for withdrawal of cash, say about 3-4 lakhs, they give 1-2 days to the customer to manage the cash from the main branch at Pasigat. So on the day, the cashier was going to withdraw from the cash from Pasigat main branch, and on that day, the accused Ramesh Yadav chased the deceased at Pasigat from 11:30 to 2 p.m. At about 2 p.m., he called me well on the way from Pasigat to Mebo and told me that he will chase the deceased by his own car up to Mebo Tenali, and from there, 103, page 103, from there he will come on foot after parking his vehicle at Mebo Tinali and asked me to observe and see whether the deceased cashier will straight away go to the bank or his resident. Then I could notice that about 2:20 p.m. the deceased cashier as usual has parked his vehicle near my shop and he entered into the bank carrying his black leather bag. Accused Ramesh Yadav told me he was carrying a withdrawn cash money in his said black leather bag. Then at about 2:30 p.m., accused Ramesh again called me from the general field, Mebo. On being asked, I informed him about the deceased cashier entering the bank after parking his car near my shop. Then he told me to close my shop at 3 p.m. and then he will come back and knock the door to discuss with me. At about 3 p.m., there was a lot of customer in the shop, so I could not close my shop at 3 p.m. as told by accused Ramesh. The accused was calling me by phone asking me to disclose the shop at the earliest. By the time I closed the shop, it was already 3:30 p.m. After about 2-3 minutes of closing the shop, accused Ramesh came to my shop and on being knocked by the accused Ramesh, I opened the door. He entered my shop and brought me a bottle of whiskey, Aussie Blues. He also brought with him one iron rod and a dagger. Then he asked me if a person is hit with the said rod, would the person die at once or not? Then I told him that if hit on the vital part, the person would fall and die. Then he asked me to go inside the bank with the iron rod and execute the plan. The plan was earlier made about 1 month back to rob the bank. It was planned to be executed on 7/2/2018, but I refused to go inside the bank at that time. He convinced me that since I am known to the deceased cashier, he will open the door for me. Then I told him that the deceased cashier is a good person and he is my customer and also a helpful person. So I told him that I cannot kill him. Then accused Ramesh told me that generally good person die early. Then I told him that the deceased cashier has 2 child, what will happen to them? Then accused Ramesh told me that if cashier die, his wife will get the job. Then we took alcohol inside my shop. After taking 2 pack of whiskey, the accused Ramesh told me that in his leather bag at least the cashier withdrawn had carried about 7 to 8 lakhs cash money from Pasigat Bank, with which he himself seen with his eyes. We kept on discussion about the money. I told him that 7-8 lakhs money by now must have been kept inside the locker. Then he told me that he has already surveyed the locker. It has a key system and the key is with the deceased cashier. If we get the key, it means we get money. We kept on discussing about the possibilities of the execution of the plan. My shop is on the above and the bank is just opposite to my shop across the road below. There was a hole in my shop from where one could see the bank very clearly. Accused Ramesh peeped on that hole and conducted the survey on the bank. He told me that at the time there were 2 more ladies staff were still inside the bank besides cashier. At about 4:30, one lady staff, Anna Perme, left the bank. Then after about 10 minutes, another lady, Tokmem Ratan, also left the bank. Now after the cashier was still alone inside the bank. Then at that time the electricity of Mebo market has gone. It was dark. Then at that time accused Ramesh told me now it was the right opportunity to go as no one would see in the dark. I was wearing a jumper at that time. Then on being asked by Ramesh, I took the iron rod and kept on my backside inside the jumper and kept the dagger in my jumper pocket. Then we both went together from the shop. As planned, I entered the bank from the front as the bank does not have any boundary wall. Accused Ramesh went towards the backside. He went across the boundary wall of the general rod on one side of the bank and hid himself behind the wall. Since the bank main door was not locked, so when I pushed it is easily open. When I entered the bank, since there was no light, the cashier was putting off the switch and ready to go home carrying his bag. Then on seeing me, he asked me in Hindi, "Arey Subhas, आप सामने होके इतना लेट में आया है." Then I told him it was late as at the daytime I had been to Pasigat. As tutored by accused Ramesh, I told the cashier that I deposited my passbook on the day time for update and came to take my passbook back. Then he told me, "Come and take." Then he went back inside followed by me. He brought out 60, 70 passbook from cashier chamber to the main counter and was selecting to find out my passbook. He was facing me back, selecting the passbook. At that time, I took an iron rod from my bag and hit him on his head, due to which he fell on the ground. Since it was dark, I took out my mobile and then torch on. I saw he was bleeding profusely from his nose, etc. Then I got scared by seeing, so I immediately called Ramesh. He was already in the bank and asked me to open the back door. And also he asked me to disconnect the CCTV so that he can enter. Then I disconnected 2-3 wires and cut about 2 wires with my dagger. The phone was still online as I was using earphone. He then asked me to asked me I had got the key of locker. And I told him the key is in the counter. Then Then I told him to come immediately. Otherwise, I walk out from the bank. Then he entered inside the bank and saw with his mobile phone that the cashier was still alive. Then he said that if he remained alive, we will be in trouble. So we were looking for something to finish him. Then he found one old battery in the kitchen. Come store, and he brought the battery and hit the deceased cashier on his head. Thereafter, the cashier died on the spot. Then we took the key from the counter kept by the cashier while searching for passbook and went to the locker room. We tried to open the locker, but it was not open. We tried 2-3 times to open the locker, but it did not open. Then he says, "Now we are helpless, we have to go back." He asked me to go back to my room. He also go back to Namsing in Tengabari. He asked me to keep my phone switch off and not call him for 2-3 months. On his direction, I wrapped up all the CCTV monitor with hard disk stabilizer, setup box, etc. in the bank's curtain and handed over to him. Accordingly, accused Ramesh took the CCTV materials and carried him to his vehicle, which was parked at Bank Tinali, and I also went back to my room. I left the dagger mistakenly inside the bank and threw away the iron rod on the backside of general ground. After reaching room, I was nervous, scared, and restless and was not at all at peace. I called one of my friend Dagang Dai to come have alcohol with me. He came to my room, which is located 30-40 meters away from my shop. We took alcohol in my room. It was around 8:30 p.m. As my room is not very far from them, we heard crying son of victim's family. On being requested, my friend, we also went to the bank to see. My friend did not know anything about the fact, so I behaved like innocent. We saw a lot of people gathered in the bank and the police were present in the bank. We were with the public till 10:30 p.m. On my request, the Gangdai also ready to stay with me at that night. The dead body of the deceased was brought to medical Mebo, which is also nearby my home. Since my house is nearby, we also joined the public burning light for whole night. Even I gave hot water to police party. The police were investigating about the case. I also gave my statement before the police stating that after closing my shop at 3 p.m. I was sleeping as I was sick. After conducting post-mortem, the dead body of the deceased was taken to village at about 12 midnight. On the next day, I heard from police friend that they have found the fingerprints and the culprit will be caught soon. So I got scared and went to my elder brother Shukumar Mandal's house and disclosed the same to my sister-in-law as my brother was not present at the time. Being scared, they left for Mebo for Janai on 9/2/2018 and on 10/2/2018 I also left for Mebo for West Bengal to my auntie's house. In the meantime, the IO B fight also called me and asked me to surrender before police. After long discussion, I decided to surrender before Jonai police. On 26/2/2018, I accordingly went to railway station Coach Bihar with a plan to surrender. My father also asked my elder brother to Sukumar to see me off at the railway station. So I went to book the ticket, and my elder brother Sukumar was on the queue to collect gate pass for his return for home. At that time, we were both arrested by the police. Okay. So basing on this, Lordship, the Honorable Trial Court has convicted the accused person. According to the Honorable Trial Court, since this is corroborating with the prosecution's case, this was a case for conviction. In my humble submission, Lordship, if we see the prosecution's case, in my humble submission, the links would be that there was a death by homicide, that the accused persons were present, that conspiracy was there between A1 and A2, that there was an act of killing, or they had a motive, or there was a mens rea, that the conduct of the accused after the alleged offense. What is seen in this case, Lordship? The death by homicide is proved. The presence of the accused in the PO has not been proved. The conspiracy, alleged conspiracy between the accused number A1 and A2 has not been proved. There are no call records, even though it is the consistent case of the prosecution that there was a conspiracy between them. That because the accused too was at Pasigat, not at Mebo. According to the prosecution, he was called from Pasigat. According to the statements made by the accused persons in 3-1, accused number 1, it was the plan of the A2. According to the prosecution, it was the plan of the A1. Whatever it is, there was a communication between them. The CDR has not been proved. There is nothing to prove that there was a correspondence even between them. The motive and mens rea, nothing has been proved. It is only the statements of the police which shows the prosecution case. Also, the conduct of the accused after the alleged offense. Their only witness on that point was also turned hostile. That point of his turning hostile, and that he has made some statements in conflict with his statements in 161. That has also not been proved through the IO, who was alleged to have recorded the statements. That question could have been put to the IO. That was not done. So there is nothing in this case, Lordship, so far as one main point for convicting the accused, saying that the accused 1 and 2 were in contact, and because there was a discovery made on the disclosure statement made by A2, some articles were found from the pawn in Tengabari. If the accused number 1 is to be connected with that discovery also, then some correspondence could have tied him to the discovery. That also cannot be done because the correspondence has not been proved. It is only the accused number 2 who is going to be, if convicted for that. It cannot be A1 because there is nothing in the evidence. So the only person who says that the PW19, the police who had allegedly arrested the accused from Kuch Bihar railway station, he has stated in his statement that before him, when they were going back from Kuch Bihar, during the journey, the accused number 1 had admitted before him that he had committed the offense, and therefore he called up the police at Mebo, Pasigat, and then asked them to arrest the accused number 2. That is the statement given by PW19. But your Lordship will find that PW19 was never examined under 161, number 1. Number 2, most importantly, this statement has not even been corroborated by the IO. Your Lordship has read the statement of the IO. While referring to SI V. Lawang, he has not stated even once that she had the accused had confessed before him that during the journey that he had been involved in the crime. That vital part is missing from the IO statement. If indeed he had, if indeed the accused number 1 had confessed before the SIV Lawang, PW 19, then that part could have been that part if he had told the IO.
That's before police officer.
Yes. In any case, yes. Even though here he is saying that he's just been made a witness, but still. So in my humble submission, there is absolutely nothing in the case to connect the accused with the crime. Now, Your Lordship, I need not go very long on this. Your Lordship knows that 313 statement by itself cannot convict the accused person. It is to be read in conjunction with other evidence. Even if we believe the statement made by the accused number 1 and 313, it is given in detail.
No.
Even then, that statement is not corroborating with the statement with the case of the prosecution. The case of the prosecution is what? That the accused number 1 is the mastermind. He was the one who called the accused number 2 and executed the plan. The statements made in 313 is exactly opposite to that. He says accused number 2 is the mastermind. He was the one who was monitoring the movements of the deceased bank cashier. He was the one doing everything. He was the one giving the instructions. And one very important thing, Your Lordship will see, in the statement of the IO, in the examination in chief, he has said that he has seized the iron rod also. But it is not part of the seizure. It is not part of the seizure. Later on, in the later part of the statement, he says that the iron rod was thrown in the river or thrown somewhere and it could not be recovered. He says that. So it seems like he's also not sure because the weapon of offense primarily seems to be, according to the prosecution, the iron rod and the stabilizer. Sorry, the UPS battery. Except for the UPS battery, the iron rod, I don't know why he says that he had seized that iron rod, which he has not done so. In that same statement, in the latter part, he says that it could not be recovered since it was thrown. That is only his statement. There is nothing, absolutely nothing in this case, Lordship. It's a very sad case that they could have done, they could not have done it. If it was done, it was a very sad thing. But this way, the conviction cannot sustain.
And from the evidence, whatever evidence has come, that they did not even take the money.
Yes, they could not take the money also.
They could not get the money.
They could not get the money. So that is my humble submission, Lordship. I'm placing some judgments. Of course, it may not be that necessary.
313.
313, yes.
It said I took out the iron rod and from my back and hit him on his head, due to which he fell on the ground.
Yes.
This is corroborating the statement, the position of the police.
No independent witness. That is what I'm saying. No independent witness at all. Not even one. Except for that part, and that also is only made by the IO and nobody else.
Of course. Anyway.
Your Lordship will only, I think in this case, we'll have to consider whether in such a case conviction can be sustained if there is only 313 and there also a 313 which is not matching with the prosecution case.
That is the sad part.
Yes. I'm relying on these citations. I'll just give the paragraph only. I'll just mark the paragraph in order to save time.
So per se, only I find only these, incriminating things that leading to discovery.
Yes, the discovery is again not connected to the
Extrajudicial confession.
Yes.
The confession was in the was made when the accused person was in the police station.
Yes.
So that will be hit. Statements before police, of course, ruled out.
Yes.
And the self-incriminating materials in 313. That again. So anyway.
Your Lordship, at the cost of repetition, even if the discovery is connecting, unless, because it is only on the part of accused number 2, unless there is an evidence of communication between them,
that
itself is, yes, my
may not be.
Yes, obliged.
You have an open mind, of course, but this was 2018, right? So, the incident was in 2018. So, para 6, this judgment. Okay, on 313. It can be used for, broad corroboration.
Yes.
13th statement on its own, because on its own it will be like a confession, and the confession cannot be used unless it fulfills all the safeguards.
Yes. May I, Your Lordship?
It can be used for missing links also in circumstantial evidence. Suppose he lies, and that suppose he makes a statement that is found to be a lie. That can be one of the missing links. But on its own, yes, ma'am. What are you saying?
Your Lordship.
You are for the
A2.
Okay.
Ramesh Yadav. My learned senior counsel had already discussed in detail, gone through the depositions. I would just keep it very brief on my part. Here,
no problem.
The conviction is based only on 313. Your Honor will see, Your Chief will see that the weapon of offense, the rod, was never recovered. Here, in this case, no eyewitness, no independent witness. And as Your Lordship has stated, no 164 confession statement recorded. Then no disclosure under section 27 of evidence also was done, which had led to the recovery, although the disclosure was not made under that. Then, however, how do we know that if the disclosure was made independently without any pressure or without any Your Lordships may go to the PW, only this part, PW 11, 12, 13. W11. PW 10, sorry. PW 10, page number 77. Here it states that Kennedy Perme. PW 10, 11, 12 happens to be the witness that has been put forward by the prosecution as to the seizure of the materials that was got from the pawn. Now PW 10, 11 and 12 consistently says that I was coming from my field, one SIB pipe stopped me near the residence of accused Ramesh Yadav. That is the deposition of PW 10. And since I was at the time ASM of Namsing village, I was made to put my signature as a seizure witness. Which means at that point of time when those things were recovered, he was not present. He was called from the village. Then PW 11 states that, page number 78, some years back, I was picked up by B Pipe to witness the recovery made from my pawn. From my pawn at Tengabari area belonging to Sri Yamut Parme GB. I saw that one monitor, stabilizer, DVR box and root were taken out from the pawn. I do not know who had kept those materials in the pawn. Then PW 12,
he states that some years back, I was picked up by SIB Pai to be a witness of seizure of material near the pond of Sri Yamut Parme. I found that accused Ramesh Yadav was already standing. On being asked by police and even on my plea to disclose about the missing materials, Ramesh showed towards a pond from where police recovered some machines in my presence, and I was made as one of the witnesses. These three, how do we say that they were an independent witness? Because the police and the accused number 2 was already in the vehicle, gypsy of the police. And how can we say that it was, whether it was implanted or what? And one more thing, the IO, PW 17, page number 89. He, in his deposition, states that he admitted that one Regon, surname from Assam, dived into the pond to retrieve those materials, but he was never made a witness, or his 161 was never taken.
One who died, the diver.
Yes, the diver, which is
No, even that would have.
Yes, Your
so
Honor.
much.
Then he and he also admits that the charge sheet was yes, sir. I have said the charge sheet in the cross, page number 93, last para. It is a fact that one person having Regon surname, who is said to be from Assam, was present, and he was a person who dived and brought out the electronic gadgets. It is not a fact that the said person having Regon surname informed me about the presence of the gadget in the said pond or at Tengabari. Now the thing is that he had never made him a witness in the disclosure statement, or else even his 161 was taken, or he was made a prosecution witness in this case.
But PW 11, 12, they were there when it was taken out.
Yes.
Except the PW 10.
Yes, but
10 and 11, to 11 and 12, PW 11, 12, they were there.
PW 10, 11, 12.
11 and 12.
Yes.
10 was shown that this monitor, stabilized, DBR, router, the police vehicle.
Yes.
But 11, 12, they were there when it was taken out from the pond.
They claim to be present.
Anyway,
that is the main incriminating matter.
So
that's all.
No disclosures. Then as my learned senior had already stated that the CDR record, because continuously the IO had tried to make this case as a circumstantial evidence based on.
No, it is based on
circumstantial evidence. The record of CDR of the accused persons to ascertain whether the meeting of minor common intention, the CDR was never retrieved. And continuously PW 7 and PW 9 says that there was blood in the UPS battery, but that blood samples were never taken for CFSL, or neither the DNA test of the accused also were to ascertain, neither the fingerprints were taken from the PO. Then CFSL report, as already stated, that could not be retrieved. In the FSL report, it is shown. We are left only with one question, is that if whether 313, as my learned senior had already stated, of the accused person, which is not given an oath or cross, can be considered as a confessional statement, and whether a conviction can be passed bearing on 313. Your lordships already know that it cannot be taken, 313 made whatever is stated by the accused, it cannot be a substantial evidence, but it could only be used as a corroborative. And a conviction basing on that has to have other independent connection or independent witnesses to corroborate it. Then the recovery without disclosure statement under section 27, how authentic that recovery is, because how do we know whether it was implanted or not? That's my submission, Your Lordship.
Yes.
May it please your lordship. Lordship, before going on to the record, my lord, the vital question posed before this honorable court is, my lord, whether the admissibility of section 313. My lord, that in 313 there are 5 subsections, my lord. And in this kind of cases, my lord, we have to look into subsection 4 of 313, my lord, and which has been, since, my lord, all the fact has been read out by the learned senior counsel, my lord, senior colleague, my lord. Now, so far as 313 subsection 4 is concerned, my lord, it has been dealt by the Supreme Court, my lord, in many occasions, my lord, that my lord,
Conviction is admittedly based on 313 and
the other, my lord, additional evidence. We cannot ignore the evidence under section 20.
not recovered the rod, iron rod.
Road has not been
And
recovered, my lord.
whatever materials you have recovered.
Yes, my lord.
Leading to the discovery.
Yes, my lord.
It has not been followed properly. Procedure has not been followed, and there's no this FSL report is negated.
My lord, the FSL, so far as my lord is well aware, my lord, FSL in all case, my lord, merely because the material has not sent for the FSL report, for want of FSL report, my lord, the accused is not entitled for acquittal if there are sufficient other overwhelming evidence is there, my lord. Since this case is absolutely based on circumstantial evidence.
There's no overwhelming. There's no material at all.
No, my lord. My lord, may kindly allow me to rely on judgment of the Supreme Court. My lord, why? Because we have to start from, my lord, 313 subsection 4, my lord.
Yes.
There are cases, my lord, wherein, my lord, first I will rely, my lord, this judgment of the Honorable Apex Court, my lord.
No, CRPC, ma'am.
CRPC, not IPC. Yes, you start from 313.
Yes, my lord, I have to start from 313. Later on, I will come with the, my lord, the other additional evidence with laid by the prosecution, my lord. Because, my lord, this is a very peculiar case before this honorable court. Earlier, prior to that, my lord, we have never come across the cases wherein, my lord, under 313, the accused has pleaded guilty, in fact, my lord.
In fact, no, the answer to the first question.
Yes, my lord.
The 313.
Yes, my lord.
Is unusually detailed, you know. It's so much, he's told everything.
Yes, told everything, my lord.
You know, the confessional statement before, is it similar to the statement before?
No, my lord, it's an admission, my lord. My lord will deal with, the Supreme Court has deal with the judgment, my lord. Which was reported in, my lord, I will read out the, my lord's citation. AIR 1992 Supreme Court 2100. My lord, here the infamous case of the Operation Blue Star, my lord, wherein one of the officer who was the part of the operation, he was, my lord, assassinated. And the accused on this particular case, my lord.
General Vaidya.
Yes, on 313, my lord, they were, my lord, relying on that the consideration of the other evidence laid by the prosecution. So, my lord, the case is of state of Maharashtra versus Sukhdev Singh, my lord. I will, my lord, directly rely on para 51 to 53, my lord. My lord, even, my lord, we all know that the 313 is not a substantial piece of evidence, but has a corroborative value. But in these circumstances, my lord, how it has to be read, my lord, 313 subsection 4.
Okay.
My lord, para 51 onward. May I read, my lord?
Para
51.
51.
Yes, my lord.
Yes.
May I read, my lord? That brings us to the question whether such a statement recorded under 313 of the court can be constituted the sole basis for conviction. Since no oath is administered to the accused, the statements made by the accused will not be evidence stricto sensu. That is why subsection 3 says that the accused shall not render himself liable to punishment if he give false answer. Then comes subsection 4, which read, the answer given by the accused may be taken into consideration in such inquiry or trial and put in evidence for against him in any inquiry into or trial for any other offense, which such answer may tend to show he has committed. Thus, the answer given by the accused in response to his examination under section 313 can be taken into consideration in such inquiry or trial. This much is clear on plain reading of the above subsection. Therefore, though not strictly evidence, subsection 4 permits that it may be taken into consideration in the said inquiry or trial, see so and so, so and so. This court in the case of Hete Singh versus State of Madhya Bharat, reported in so and so, held that an answer given by the accused under 313 examination can be used for proving his guilt as much as the evidence given by the prosecution witness. In Naren Singh versus State of Punjab, this court held that if the accused confessed to the commission of the offence with which he is charged, the court may, relying upon the confession, proceed to convict him. To state the exact language in which the three-judge bench answered the question to it would be advantageous to reproduce the relevant observation at the page so and so. Under section 342, that is 313, of the Code of Criminal Procedure by the first subsection, insofar as it is material, the court may at any stage of the inquiry or trial and other after the witness for the prosecution has been examined and before the accused is called upon for his defense, shall put question to the accused person for the purpose of enabling him to explain any circumstances appearing in the evidence against him. Examination under 342 is primarily to be directed to those for matter on which evidence has been laid for the prosecution to ascertain from the accused his version of explanation, if any, of the incident which form the subject matter of the charge and his defense. By subsection 3, the answer given by the accused may be taken into consideration at the inquiry or the trial. If the accused person is in his examination under section 342 confess to the commission of the offense charged against him, the court rely upon the confession proceed to convict him. But if he does not confess and in explaining circumstances appearing in the evidence against him set up his own version and seek to explain his conduct, pleading that he has committed no offense, the statement of the accused can only be taken into consideration in its entirety. Subsection 1 of section 313 corresponding to subsection 1 of section 342 of the old code, except that it now stand bifurcated in two parts, with the proviso added thereto clarifying that in some case where the presence of the accused is dispensed with, examination under clause B may be dispensed with. Subsection 2 of section 313 reproduce the old subsection 4 and the present subsection 3 corresponding to the old subsection 2, except for change necessary on account of abolition of every jury system. The present subsection 4 with which we are concerned is a verbatim reproduction of the old subsection 3. Therefore, the aforesaid observation apply with equal force. Even on the first principle, we see no reason why the court could not act on the admission or confession made by the accused in the course of trial or in his statement recorded under 313 of the court. Under section 12.4 of Tada Act, a designated court shall, for the purpose of trial of any offence, have all the power of the court of session and shall try such offence if it were a court of session, so far as may be in accordance with procedure prescribed in the court for the trial before a court of session, albeit subject to the other provision of the Act. The procedure for the trial of the session case is outlined in chapter so and so. According to the procedure provided in chapter, after the case is open is required under section 226. It, upon consideration of the record of the case and the documents submitted therein, the judge considered there is a sufficient ground for proceeding against the accused. He shall discharge the accused for reason to be recorded. If, however, the judge does not see reason to discharge the accused, he is required to frame in writing a charge against the accused as required by section 228 of the code, where the judge frame the charge. The charge so framed has to be read over and explained to the accused, and the accused is required to be asked whether he plead guilty of the offense charged or claim to be tried. Section 229 next provides that if the accused plead guilty, the judge shall record the plea and may in his discretion convict him thereon. The plain language of this provision shows that if the accused plead guilty, the judge has to record the plea and thereafter decide whether or not to convict the accused. The plea of guilty tantamount to an admission of all the facts constituting the offense. If it is therefore essential that before accepting the acting on the plea, the judge must feel satisfied that the accused admit fact or ingredient constituting the offense. The plea of the accused must therefore be clear, unambiguous, and unqualified, and the court must be satisfied that he has understood the nature of the allegation made against him and admit them. The court must act with caution and circumspection before accepting and acting on the plea of guilt. Once these requirements are satisfied, the law permits the judge trying the case to record a conviction based on plea of guilt. If, however, the accused does not plead guilty or the learned judge does not act on his plea, he must fix a date for examination of the witness. That is the trial of the case. There is nothing in this chapter which prevents the accused from pleading guilty at the subsequent stage of the trial. But before the trial court accept and act on the plea, he must administer the same caution unto himself. This plea of guilt may also be put forward by the accused in his statement recorded under 313 of the court. In the present case, beside giving written confessional statement, both accused number 1 and accused number 2 admit to have involved in the commission of murder of General Vaidya. We have already pointed out earlier that both the accused has unmistakenly, unequivocally and without any reservation whatsoever admit the fact that they were responsible for the murder of General Vaidya. It is indeed true that the accused number 1 did not name accused number 5 as driver of the motorcycle. Perhaps he desired to keep him out, but accused number 5 has himself admitted that he was driving the motorcycle with accused number 1 on the pillion seat, and to facilitate the crime, he had brought the motorcycle in line with Maruti car so that the accused number 1 may have an opportunity on firing at the victim from the close quarter. There is therefore no doubt that both accused number 1 and accused number 5 were acting in concert. They had a common intention to kill General Vaidya, and in furtherance with that intention, accused number 1 fired the fatal shot. We are therefore satisfied that the learned trial judge has justified in holding that the accused number 1 was guilty under section 302 and was guilty under section 302 of the IPC. Now 53, my lord. As pointed out earlier, learned counsel for accused number 1 and 5 contended that although a statement recorded under section 313 of court can be taken into consideration in an inquiry or trial, since it is not evidence is stricto sensu and not being under oath, it is little probative value. Reliance was placed on R.B. Chaudhary case so and so. In support of this proposition, the two decisions of the High Court on which our attention was drawn did not in fact militate against the view which we are inclined to take in regard to the admission of the guilt made by the two accused in their statement recorded under 313 of the court. In the case of Jit Bahadur Chetri, reported in so and so Gauhati, only one witness was examined, and immediately thereafter the statement of the accused was recorded under 313 of the court. The deposition of the sole witness did not reveal that he had seen the accused causing the injury in question. The question that was framed was not consistent with his evidence, and hence the High Court found that the trial court had acted illegally. It was held that such an answer cannot be construed as pleading guilty within the meaning of the provision of the court, and hence the learned magistrate has acted contrary to law in convicting and sentenced the accused on the basis of the death plea. It will thus be seen that the court came to the conclusion that the accused could not be stated to have pleaded guilty, and hence the convict was set aside. In other case of Osokan, the High Court of Kerala pointed out that in criminal case, the burden of establishing the guilt beyond reasonable doubt lies on the prosecution, and that burden is neither taken away nor discharged nor shifted merely because the accused set up a plea of private defense. It was pointed out that if the prosecution has not placed any incriminating evidence, such an evidence made by the accused will be of no avail unless the admission constitute an admission of guilt of any offense. In that case, also the admission made by the accused read with whole did not constitute an admission of guilt of the offense charged. On the contrary, it was the nature of a plea of the private defense. In circumstances, the High Court came to its conclusion that the absence of unequivocal, unmistakable, and unqualified plea of guilt, the court could not have convicted the accused of the statement made by under 313. The decision also does not therefore help the defense, my lord. And here 313 has been taken into consideration, my lord. Along with the the evidence.
There was a written confessional statement. Yeah. And the accused were even not remorse; they were rather proud of their action.
And on the on that confessional statement, my lord, there was nothing about the other co-accused, my lord. That was there. There was nothing because he wanted to, my lord. Perhaps he wanted to protect the one of the co-accused. But in 313, that was taken into consideration.
It's okay; it can be taken into.
Yes, my lord.
In the case, the accused, they were proud of their action, their offense, commission of the offense.
Yes, my lord.
And there was a clear written confessional statement.
Yes, confessional statement. But my lord, here the 313, on the 313, the stress has been given, not on the confessional statement.
In the present case, there's no 164 statement also.
No.
164 statement is not there, my lord. No doubt, my lord. No, that the same judgment has been taken into consider by our own High Court, my lord.
I'll just pause for.
Yes, my lord. Yes, my lord.
What happens is, this is a famous case.
Yes, my lord. Yes, my lord.
Sukhdev Singh.
Yes, my lord.
Right? General Vaidya's assassination.
Yes, my lord.
Case, right?
Yes, my lord.
So, if we accept the, if we say understand the interpretation of this judgment,
yes, madam,
as holding that if there is a confession, if there is an admission of guilt,
yes, madam,
statement under section 313 CRPC,
yes, madam,
right?
Yes, madam.
And that would be similar to a plea of guilt.
Yes, madam.
Subsequently,
Yes, madam.
you know, plea of guilt is before charge.
Yes, madam.
He does not plead. The charge is framed, trial proceeds.
Yes, madam.
But subsequently also, this judgment is also an authority for that proposition.
Yes, madam.
That subsequently also, not only at that stage,
yes.
subsequently also.
Later also, madam.
Also can be.
Yes, madam.
Can be.
Yes,
That's okay. But the question is that whether the answer to a question in a 313 can be taken as a plea of guilt. Because whenever a person wants to plead guilty,
yes, madam,
subsequently also,
yes,
he
madam,
makes an application.
Yes, madam.
And then, you know, he's asked, he's also explained the consequences of making the plea. That is, that duty would be there subsequently also.
Yes, madam.
Not only at the initial.
Yes, madam.
So that you are not bound to make, but if you make, it can be used before you. It has to be explained the consequences.
Yes, madam.
And thereafter, if he still persists on, you know, making the plea, then
Yes,
the court proceeds to record the plea.
Madam,
That is one aspect. The last thing, the second thing which I'll say, and then I'll stop. You can, is that even if we accept this, even if we understand
yes,
that this judgment has clearly held that conviction can be based solely upon the statement of the accused in 313.
Not solely, my lord. It has to be there must be an other evidence delayed by the prosecution.
Law.
Yes, madam.
That is settled law.
Yes, madam.
But that then, if we understand like that, then it conflicts with this these judgments of, you know, the recent judgments of 2024 and 14. That conviction cannot be based solely on.
But
and the quorum of these these judgments are the same. Two judges.
But my
same quorum.
lord, but earlier has to be followed, my lord. If I'm, my lord, to my humble submission, but if there is a distinct with the same
division, that's also said that's a context of a different.
Yes,
that's true. But
and my lord, one of the aspect, my lord, I would like.
Does Sukhdev Singh, does it really say that conviction can be based solely on the statement?
Not solely, my lord. Not solely, my lord. Some material, some other evidence should be there, my lord, from the prosecution side as well, my lord.
Some other material.
Because yes, my lord. Because my lord, that one of the proposition is there that during the admission in 313 admission is there. There must be an additional evidence. But my lord, so far as the other judgment, where all the judgment says that 313 is not a substantial piece of evidence, but it does have a corroborative value. So then if we go, then if we
nobody is disputing.
No, my lord, if we follow that proposition also, then my lord, the statement of the IO and the other, it does corroborate with their statement under 313, my lord. Now we cannot simply say that it's only hearsay. We cannot rely upon it.
The Learned Trial Court has solely relied on the 313.
Not only, my lord, 313, 27 also, my lord.
Have done. As you said, it has to be corroborated by other evidence.
Yes, absolutely, my lord.
Yes, in that case, they have relied solely on 313, which could not have done.
Not, my lord,
that's what you are saying.
My lord, they are saying, but
because there is no other corroborated.
My lord, section 27, my lord, the discovery of fact. Now, my lord, the issue which was never put before the trial court, they have never raised any anything during the cross. That issue cannot be raised at the stage of appeal, my lord. Now they are saying the 27 is not applicable here. They are disputing 27, but they have not taken that plea before the trial court. Why it is not applicable? One of the aspect, my lord. That is also one of the aspect. And my lord, so far as the 27 is concerned, that is not only confined for, my lord, the discovery of evidence under 27. It is also, my lord, applicable for section 8, doctrine of, my lord, the confirmation by subsequent conduct, my lord. That will also apply, my lord, for under section 27, the disclosure evidence. And my lord, I would like to bring the attention of this court, and my lord, page number 29, my lord.
Just a minute. So if so, I'm just going back to the earlier point that if that be so, that if this judgment, the famous judgment of Sukhdev Singh,
yes, ma'am,
you know, does not lay down the proposition that it can be based, conviction can be based only on the 313 statement.
Yes, ma'am.
And that it can be used, it can only be used with other evidence. Then this 92 judgment is in harmony with the recent judgments.
Yes, ma'am.
Then there is no conflict.
Yes, ma'am.
Because the point enunciated in the recent judgments is that it can be used. Certainly, there's no doubt about that. It can be used.
My lord, the pool bench judgment
Then
also,
it's
my lord.
in harmony. Yeah.
Yes, ma'am.
Yes.
On that aspect also, my lord, one more judgment, my lord, that
It is settled. Nobody is disputing it. It's settled. What the issue is, we thought the conviction can be based solely on the 313 statement. It's not a case.
yes,
It cannot be.
it cannot be, my
It has
lord.
to be corroborated. It's settled. Anyway, you give
But for my satisfaction, my lord.
not satisfied. We also don't know. At least they
Ultimately, I have to demonstrate the case, so my lord. And before that, my lord, I would like to draw your lordship attention on page number 29, my lord.
One point that bothers me is that what if we suppose, for argument's sake, if
Okay,
we think in different directions. Suppose that's settled, no doubt. What my brother said, that whether, as you have tried to argue, whether self-incriminating statement, on the during 313 examination,
yes,
could be taken as a subsequent plea of guilt. Right. Subsequent plea of guilt can be done subsequently. This is settled by Sukhdev.
Yes, madam.
Okay. We have used it also in our trials. So whether the self-incriminating statement under 313 can be taken as a it can certainly not be a confession, because confession has so many checks and balances.
Yes, yes.
A confession cannot be taken if the person is coming from police custody.
Yes, ma'am.
Right.
Yes.
So many other checks and balances.
Yes,
the magistrate has to give him reflection time. So this cannot be a conflict. But can it be a plea of guilt? Probably no. Because plea of guilt also, as I said, it does not have those checks and balances of a confession. But still, you have to, it has to be on the request of the person.
Yes,
that do you plead guilty? He has to be asked, and he has to be explained the consequences of pleading guilty.
And my lord, there is not only 313 statement of this accused. Other accused also, my lord, stated the same, my lord. He has also explained. My lord, I will read out. But my lord, before that, my lord, may kindly come to page number 29, where one of the accused has already plead guilty, my lord. But the learned trial court has proceeded, because if the offense is of heinous offense, the normal practice is, my lord, the
accused.
Yes, my lord.
Who
was pleaded guilty initially? The
Subhas Mandal, my lord. It is page number, my lord, 20.
He always had those guilts.
No, other have not
knew the disease. I mean, I'm not saying it's proved, but the thing is that, I mean, as for the story.
In fact, he has admitted everything, but you could not prove it, despite admission. Honestly, confession.
Anyway, please proceed.
So that's the sorry. I mean, sad part.
8 years. It is an investigation of 8 years back. Okay. If today this was the investigation, then the best thing for the IO to do is that the dagger was left inside the allegedly. The dagger was left inside the bank branch. And one of the accused allegedly carried these electronic materials and threw it. All you have to do is get the fingerprints, get the DNA, try to match it.
Yes, madam.
Because DNA is a very accurate science.
Yes,
Only thing that that is important in DNA fingerprinting is that the chain of custody.
Yes, madam.
Chain of custody.
Yes, madam.
The sample which is sent is the sample which is examined.
Yes, madam.
But the science is very accurate, almost 100%.
No doubt, my lord, the admitting that sorry investigation was done, but my lord, but from the material whichever before this honorable court, my lord, to my humble understanding, my lord, that will also be suffice to uphold the conviction, my lord. My lord, the second case, my lord.
Any time you do not get a second chance in life. That's
yes, absolutely, madam.
Yes. Yes. Because now probably you would know, the IO would know, because there are a lot of awareness now.
Yes, my lord.
Scientific evidence. 2018, still 8 years back. Anyway,
this is AIR 1978, AIR SC 315, my lord.
Since we have a single bench also, can we continue tomorrow? How long will it take?
I won't take much time, my lord. I will rely this one and I will make a conclusion.
Half an hour. Half an hour?
Half an hour? 50 minutes. No, you are appealing for the... No, yes. He has to be given.
You have to establish the evidence or what?
No. You have to have full satisfaction.
I'll rejoin the PTO.
Defending
Problem is we cannot
tragic case.
say that we
I think
not hear you, but then what's there? Let's do one thing. We'll fix it tomorrow. We'll hear you for 1 hour tomorrow.
half an hour and
First,
then
half an hour.
some reply.
Half an hour.
Tomorrow, my lord.
See, we'll have to balance. Single bench is also there. Otherwise, no problem.
Yes, my lord. But that is there, my lord.
Then the members are you ready till 7 o'clock? or maybe 6 o'clock? No,
Chamber,
seriously.
chamber work is also there.
We continue tomorrow. It would not be fair.
No, if it is half an hour, we can hear till 4 o'clock. In fact, we want to complete
Whatever my senior brother says.
Another cases.
Yes.
Yes, what do you say?
Yes, my lord.
Tomorrow or continue?
Continue, we can.
You are for 15 minutes. You will give you 15 minutes. Please complete by 35 minutes.
Okay, my lord. Then tomorrow.
Yes.
Till 4 we can.
Okay, my lord.
And then whatever is we can manage in single bench, we'll do it.
Hello, then my lord, the second judgment, my lord, that is reported in AIR.
Because you are arguing very spiritedly as a good prosecutor, so don't want to break that momentum.
Break the tempo. Which one?
My lord, AIR 1978 by the full bench, my lord.
Para?
My lord, para 19. 19 and 20, my lord. May I read, my lord? There was at one point of time some controversy whether the statement of the accused can be accepted in part and rejected in part. This situation arose where a part of the statement was inculpatory and a part of the statement was exculpatory. In Narayan Singh versus State of Punjab, so and so, was held that it is not open to the court to dissect the statement and to pick out the part of the statement which may be incriminative and then to examine whether the explanation furnished by the accused for his conduct in support by the evidence on the record. If the accused admit to have done an act which would, but for the explanation furnished by him, be an offense, the admission cannot be used as against him divorced from the explanation. The question again figured out before this court in Nishikant Jha versus State of Bihar, wherein the court held that the court may rely on the portion of the statement of the accused and find him guilty in consideration of the other evidence against him laid by the prosecution. In Nishikant Jha case, there was no eyewitness to the commission of the crime and the evidence was all circumstantial, and the statement of the accused that he has present in the scene of the crime was a vital circumstances which taken in conjunction with the other circumstances led by the court to come to the conclusion that he was guilty of the crime imputed to him. The ratio of the aforesaid case was again examination in Sampath Singh versus State of Rajasthan. On the fact of the case, after accepting a part of the statement of the accused, it was held that the injury caused injury in exercise of this right of self-defense, but they exceeded the same. It was observed that it is permissible for the court to rely on the portion of the statement of the accused and find him guilty in consideration of the other evidence against him laid by the prosecution. Where the commencement or genesis of the occurrence is not available because there was no witness of the occurrence available, the only direct version of the commencement of the occurrence would be found in the statement of the accused. If he chooses to give out his version of the occurrence, his statement has to be considered in light of the evidence adduced by the prosecution and weighing his statement with the probabilities of the case either in his favor or against him. My lord. Here also, my lord, the portion of the statement of the accused can be taken into consideration in, my lord, conjunction with the evidence adduced by the laid by the prosecution, my lord.
Yes.
My lord, now, my lord, so far as 313 is concerned with the one of the accused, that has already been read out, my lord. Other co-accused is also there, my lord, wherein he has admitted his, my lord, part in the commission of the offense.
Accused number 2.
Yes, my lord.
Yes.
A2, right?
Accused number actually.
Ramesh Jadhav.
Ramesh, my My lord, yeah, the page 114, my lord. May I read, my lord? Page number 114. My lord, one is the incriminating circumstances, which was where the accused attention was drawn. Answer is, I would like to tell the detail of the incident. Earlier, I have given my statement before the police, which is with the charge sheet, but the
Sorry.
which is with the charge sheet, but the police has not recorded my statement properly.
Is that page?
My lord, page 114 of the second volume, my lord.
Yeah.
Second volume.
Please carry on. I'll follow. Yeah. Statement of Ramesh Jadhav.
Yes, my lord. My the answer to the incriminating circumstances. Answer. I would like to tell the detail of the incident. Earlier, I have given my statement before the police, which is with the charge sheet, but the police has not recorded my statement properly. They have recorded my statement basing on the statement of accused Subhas Mandal. So, I would like to give the detailed statement of the fact before this court. Subhas and me were planning to loot the rural bank for about 3 months prior to the incident. In fact, we tried to attempt once, but at the time, Subhas informed me that there were so many people around the bank, so we dropped the attempt at that time. In the meantime, we had been kept discussion and planning over phone. On the incident day, I came to Pasigat for some work. On being called by Subhas, I went to Mabo in my car around 4 p.m. I parked my vehicle in highway, and Subhas' shop is located just opposite to bank, going upper side of the highway. Then we discussed in his shop, and we also took 1 quarter bottle and whiskey while discussing. Later on, Subhas closed the shop. He asked me to watch for the people from the field near the bank, and he himself will go inside the bank. He also told me to call him immediately if anybody comes inside the bank. Then he entered inside the bank after sending me in the field. I did not see the time, but it was dark by then. One could see from near, but cannot see from distance. After some time, he called me from inside the bank and asked me to inform him by giving him missed call twice if anybody approached toward him. After about 15 to 20 minutes, Subhas came out from the bank from backside.
Here again, no 115.
115 page.
115 is it's okay.
We can use.
Yes.
And the 115.
It's okay. It's okay.
Okay. And after 15 to 20 minutes, Subhas came out from the bank from backside toward the field side with a bundle wrapped in curtain. He handed me over and asked me either to bury it inside the soil or to throw it in the water. And he will discuss with me on the next day. On being asked about the money, he told me that it was not right time to talk about and it will be delayed, and told me that he will discuss with me tomorrow or some other time as and when the time permits. Then I took the wrapped item and went to Namsing at Tengabari area and threw it to the pond in the Tengabari area. Before throwing the item, my lord, here it's again corroborating, my lord, with the statement. The pond Tengabari area. Before throwing the item inside the pond, I saw that it was a CCTV material like DVR box, etc. Thereafter, I went back home. At home, I loaded Sarso Papad in 407 vehicle, which was to be taken to Pasigat on the next morning. On the next morning, the vehicle had gone to Pasigat, and after some time, I heard a murder took place in rural bank at Mabo. Then was a hue cry at Namsing village also. Then I also get scared and could not disclose the last evening incident to anyone. I spent 2-3 days just thinking about what to do and what not to do. I was wondering how accused Subhas could murder a person. And after few days, I heard that Subhas Mandal fled Mabo along with his other family member. I could not disclose the incident due to fear of being arrested. Later on, the accused Subhas was arrested from the West Bengal. He might have disclosed that I was also present with him in the bank in the incident evening, so the police has arrested him. During interrogation, I narrated the entire fact of the incident evening and also disclosed that I threw the CCTV material wrapped in the curtain handed over to me by the Subhas Mandal in the pond at Tengabari. On being asked, I led the police to the pond at Tengabari and shown them the place where I threw the CCTV item from where the police has recovered the same from the pond with help of the one boy. They took the recovered material and brought them back to the police station. After keeping me for some day in the Thana, I was sent to judicial custody. My lord, now the statement again here, my lord, it's corroborate, my lord. So far as the 27 is concerned, my lord. And my lord, so far as the admission part, my lord, it is now, my lord, settled that the court can rely on the portion of the statement regarding the admit of guilt by the accused, my lord. That can be taken into consideration. But other additional evidence, my lord, has to be looked into. And the evidence is, my lord will see the conduct also, my lord. The family member of the Subhas Mandal and Sukumar Mandal, my lord. The Sukumar Mandal is in fact is the brother of the accused Subhas Mandal. Their family left, my lord, the Merbo. Then they went to Jonai. From there, they left, my lord. So the conduct is also a relevant factor. The conduct also, my lord, is because this, my lord, this case is absolutely based on circumstantial evidence, my lord.
Leaving the half-eaten food and some curry.
That is, my lord, that is only confined to the accused Subhas Mandal, but the family member, because he has informed the family member that he has murdered the cashier, my lord. And my lord, his brother-in-law, my lord, I will read the statement of the Sukumar brother-in-law, where he has stated that after coming out from the bail, he has been told that his brother-in-law's brother, that Subhas Mandal, and his friend has committed the offense of murder by killing the cashier. That is also there in his deposition, my lord. That is also incriminating material against them, my lord.
Whose deposition?
My lord, the deposition, PW8, my lord. My lord, because even if he is declared hostile, his statement cannot be discarded in toto, my lord.
Page 72.
Page 72, my lord. My lord, cross, my lord, by the PP. Page 73. My lord, in the third last paragraph, my lord. It is a fact that after release from the jail, I had confirmed that the brother Subhas Mandal of my brother-in-law and other has killed the cashier of the Rural Bank of Merbo, my lord. There is no any cross as such, my lord. No cross from their end, my lord. Because once he is done hostile, my lord, even they can, my lord, cross this accused person, this person, my lord. And my lord, it is well settled that the witness must be examined. It's all part of his statement, my lord. Otherwise, his statement will be accepted as true, my lord. Here, my lord, this part was not crossed, my lord. This also corroborate with the statement, my lord. This is not a case where on 313, solely on the basis of 313, the accused were convicted, my lord. There are other, my lord, substantive evidence, my lord, material evidence, which does corroborate with the admission made by the accused, my lord, in 313. And so far as, my lord, the injury is concerned, my lord, the inference can be drawn from the injury report itself, my lord. Because, my lord, as per the report, it was a legislation, my lord, the nature of injury, my lord. That injury, my lord, as per their statement, they said he has taken out the rod and hit his head on the back side, my lord. Now, the nature of injury, my lord, the injury usually, my lord, is laceration, my lord. It usually caused by the, my lord, the blunt force impact, my lord. It's a split or tear of, my lord, the muscle, skin or body tissue that caused by the blunt force impact, my lord. Although the weapon was not recovered, my lord, the circumstances, my lord, the surrounding circumstances, that does corroborate with their statement, my lord. Only on the isolation, my lord, only on the reading the 313, he was not been convicted. There are other, the evidence are there, my lord. The UPS by which he was, his head was smashed, my lord. That UPS was recovered, my lord.
With blood stains.
Yes, blood stains were there. And non-sending of the blood stain for FSL, it will not pertain to the prosecution case, my lord. And the material, my lord, that were recovered from the section 27, my lord, is clearly established. Because in 313, even for the sake of argument, my lord, if we taken a 313 for the corroborative purpose also, that does corroborate with the statement of IO, because 27 statement will be definitely given before the IO. That is the prerequisite, my lord. That was given, and he led the IO, and before the 3 witnesses, my lord, it was recovered. And his statement does corroborate under 313.
2 witnesses, not 3.
3, my lord.
3 was shown in the car only.
Yes, shown in the car, my lord. Shown in the car, my lord. The question here is whether they have discredited the statement of the witness, my lord. They have to discredit the statement by exercising the, my lord, the procedure under 145, my lord.
So PW 11 and 12.
Yes, my lord. They simply, my lord, on the basis of record, my lord, they cannot compare the statement. They have to follow the procedure under the Evidence Act, my lord. Contradiction, corroboration, my lord, 145 Evidence Act. We cannot, my lord, read in isolation. Otherwise, my lord, 161 statements are there, are very clear. But we are not relying on 161 statement because prosecution has not bring it into the record by way of cross-examination or contradicting any evidence or any deposition of the prosecution witness, my lord. Here, one of the accused has turned hostile. Later on, he himself has admitted that after coming out of the jail, he learned that his brother-in-law's brother has committed the offense along with one of the co-accused, my lord. That is also an incriminating material. That is substantial piece of evidence, my lord. That has not been disputed.
He was also an accused. PW.
No, my lord. He's a prosecution witness.
You said accused. That's all. That's all.
Yes, my lord. And my lord, I will on the conduct also, my lord. Conduct, my lord, the throwing of the the CCTV footage and the DVR, it was although recovered, but nothing can be find out from that, my lord, this DVR. Why? Because it was thrown in the water. And the accused were indeed has a conspire, my lord. They have pre-planned and they have executed their plan. And my lord, they were aware that for taking the key of the locker, they have to eliminate the cashier because they were aware that the cashier was inside and they are following the cashier right from the beginning, my lord. It is not a case that they only went inside to rob the bank. It is a case where they have planned to eliminate the cashier, then rob the bank. But unfortunately, they failed to rob the bank, but they have eliminated the one innocent person, my lord. And the material which was used for commission of the offense, one of the material, although the rod was not recovered, but my lord, the UPS which was used in the commission of the offense was recovered, my lord. It's a substantial piece of evidence, my lord. They are not disputing it, that it was not used.
UPS battery.
Yes, my lord. They are not disputing it, that whether it was used or not. Because, my lord, we have to argue on the basis of the record, my lord.
Then disastrously failed, but end up with physically.
Yes, my lord. And one innocent person suffered. My lord, we have seen the 313 statement of the accused number 2. He himself stated he is a good person. But one of the person said, good person died early and his family will get the, my lord, see their intent, my lord, the level.
There was the motive, I mean the intention.
No,
to kill.
No, my lord. He said.
The intention or plan is only to rob the bank.
No, my lord. From that, he said, good people died early, and if he died, his wife will be compensated to get the service. That itself, from there, inference can be drawn that.
But the A2 in his statement says that he had no idea that A1 wanted to murder.
From his statement,
he shifted the blame to A1.
Yeah, blame to A1, my lord. The other, my lord, attending circumstances, my lord,
both the accused are trying to in 3313
shifting, yes, that is there. But my lord, they conspire and they have the common intention, my lord. That is there, my lord.
Okay.
And if, my lord, to my understanding, if 313, the portion of the 313 has to be taken into consideration with the portion of the statement, my lord, which has been stated by admitted by the accused, that has to be taken into consideration along with the other, my lord, the evidence laid by the prosecution. Definitely. Then this, my lord, in fact, indeed, no doubt there was some error by the investigation authority, but this is a case for, my lord, upholding the conviction, not for, my lord, acquittal. I will rest my case, my lord.
Yes.
don't have much to say, my lord. Since the PP has covered everything, my lord. PW 19, PW 16, 17, 19, my lord. They are the police witness, my lord. So they are also, my lord, necessary. They are also their evidence. Their statements are also evidence. They are also credible witness, my lord.
You are appearing as amicus?
Yes, no, victim.
Okay. Private
For
capacity.
that only, I will like submit one judgment, my lord. The statement of police cannot be discredited solely. 2001, 1 SSC, 652.
Page number
652, my lord.
2000?
2001, 1 SSC, 652. my lord.
Sunil.
652.
Yes, ma'am.
Where?
Para 21, my lord.
Okay, thank you.
Statement of police is also reliable, my lord.
There are 21.
21, my lord. May I read, my lord?
Yes.
We feel that it is an archaic notion that actions of the police officers should be approached with initial distrust. We are aware that such a notion was lavishly entertained during the British period, and the policemen also knew about it. Its hangover persists during the post-independent years, but it is time now to start placing at least initial trust on the actions and the documents made by the policemen. At any rate, the court cannot start with the presumption that the police records are untrustworthy. As a proposition of law, the presumption and presumption have been regularly performed as a wise principle of presumption and recognized even by the legislature. Hence, when a police officer gives evidence in court that a certain article was recovered by him on the strength of the statement made by the accused, it is open to the court to believe that the version of it to be correct if it is not otherwise shown to be unreliable. It is for the accused, through cross-examination of witnesses or through any other materials, to show that the evidence of the police officer is either unreliable or at least unsafe to be acted upon in a particular case. If the court has any ground reason to suspect the truthfulness of the records of the police, the court could certainly take into account the fact that no other independent person was present at the time of recovery. But it is not legally approvable procedure to presume that police action is unreliable to start with, nor to jettison such action merely on the reason that police did not collect the signature of the independent persons in the documents made contemporaneous with such actions. So when there is a discovery of material, my lord, the police statement can be relied, my lord. Since, my lord, PW9, my lord, or PW19, my lord, PW17, PW16, my lord. PW16 is OC, my lord. Yeah, my lord. On the statement of OC, my lord, PW, it will be page 85, my lord.
We have seen it already.
Yes, my lord. Their discovery has been made, my lord.
Yes.
And PW17, my lord, PW17 is the IO of the case, my lord. So his statement is also credible, my lord. And PW19, my lord.
PW 17?
17 is the IO of the case, my lord.
Yes. Then
PW16 is the OC.
16 and
16 and 19, my lord. The police officer who arrested the accused person, A1.
A1.
Who has arrested the A1, my lord? And by whom, my lord? The name of A2 came into, my lord, effect, my lord. A1 confessed, my lord, before the PW19, my lord. That A2, my lord, A2 is also involved in the offense, my lord. Now, this way the consideration might be made by the London trial court, my lord. May I take your lordship to judgment of the trial court, my lord? Judgment is at page 127, my lord.
Page
127 is the judgment, my lord. Now, consideration made by the London trial court is at page 146, my lord. PW17 Inspector B. Payet, my lord. And my lord, in in page 147, Roman 17, PW 19, my lord. Their statement was also, my lord, taken into consideration, my lord, while delivering the judgment, my lord.
Forty-six, 47,
46,
48.
146.
Page 146 to 148.
Yes, my lord. 147, yes, 147, 148, my lord. 146, 147. 146, my lord, is in relevant to PW 17, my lord, IO of the case, my lord. The statement of, my lord, my submission is the statement of police cannot be discredited, my lord, solely because they are police, my lord. When there has been some recovery, my lord, discovery of documents, my lord. The consideration, my lord, of the judgment, my lord, by the London Trial Court was statement under section 313, my lord, page 129, my lord. And then in charge sheet submitted by the IO, my lord, page 130, my lord. And even, my lord, this judgment was consciously passed, my lord, in section in page 140, my lord. Section 3134, my lord, has been discussed, my lord.
One?
But 313 of CRPC, my lord, of subsection 4, my lord. By relying on the judgment of Sanatan, Naskar, and other verses in relation to section 313, my lord, the London Trial Court has, my lord, applied section 313, subsection 4, my lord. And then the evidences on record, my lord, page 143, it starts from page 143, my lord. The statement of the, my lord, witnesses, prosecution witnesses, my lord.
A1 is pleaded guilty.
No.
Yes.
Well, initially,
It
he was,
is-
initially he was pleaded guilty,
Yes, yes.
but his plea was not accepted and proceeded with it. That can be done, madam, in heinous offense. That
Yes.
usually that is
Usually that is.
the practice. Plead guilty किया था ना? Plead guilty किया.
My lord, in relation to conspiracy, my lord, page 159, paragraph 37 of the judgment, my lord.
Page?
Page 159, my lord. Paragraph 37, my lord, which was also dealt by the London Trial Court, my lord, in relation to conspiracy, my lord.
Page?
Page 159, para 37, my lord.
37.
Yes, my lord. What's for you?
Yes.
Okay. Last, my lord, one aspect I've just missed out, my lord. The brother before whom he has the accused has stated by the time when they were in lockup. Know that, my lord, that cannot be given the color of, my lord, extrajudicial confession, but it does have a corroborative value, my lord, because it was stated before by the time when they were in police custody. And that cannot, when they were in police custody, that cannot be considered as extrajudicial confession, my lord. So although it won't give the, my lord, color of extrajudicial confession, but it will take into consider as a corroborative piece of evidence, my lord, with the other evidence. And my lord, that much, my lord. I will, my lord. I've just marked the para and the relevant judgment. My lord. I will just give it to the.
Again.
No, my lord, I will not read out, my lord.
Yes.
For this case, my lord, it's relevant cases which prosecution would like to rely, my lord. Because
apart from this.
yes, not
Apart from this.
yes, apart from 313.
No, apart from which you have already placed.
Yes, my lord. That I have placed on 313 only, my lord. My lord, this regarding the issue which they are raising now, that in cross-examination, which has not done during the cross-examination, they have raised all this aspect here in the appellate stage also. For that, my lord, to cover that, my lord, the submission.
To compile and give it.
Then
you compile and give it.
Okay, ma'am.
You compiled already?
Yeah, my lord, essentially, I have mentioned everything, my lord, here.
Huh?
Okay.
I've mentioned everything with paragraphs also, my lord.
That's all. We'll record. Heard Abbott's and Dunget Legal Aid Council in criminal appeal 11 of 2022. MS SB Direct Legal for criminal appeal in 10/2023. Because we will record first her name because it was heard. Team 91 has heard first.
Yes. 90.
And her also heard Mr. T. At the learned additional PP. For the state as well as Mr. BP Chair, Learned Council for informant.
Victim. Wife of the deceased. Wife of the deceased. Yes, ma'am.
As a respondent.
Yes, madam.
Two.
Yes.
Hearing concluded, judgment. Just get those things.
Sorry, Lordship, just one thing. When your Lordship is trying to compare the statements made under 313 and the prosecution case, it may be noted that the details given in the 313 and the prosecution case is not the same.
What are you saying? The 313 statements.
Since the
deposition of the PWs are not.
The whole case projected by the prosecution. They are trying to connect the case projected by the prosecution with the 313, saying that there is some sort of corroboration. What I'm saying is, this is black and white. If the prosecution case is black, the 313 is white. It is not the same thing. There are so many differences there in the narration of the story itself.
In putting the questions, you mean?
No, in the answers.
Answers.
Yes, the answers of the accused number 1 and accused number 2 are not in consonance with the story put by the prosecution. The whole story. If they are trying to say that there is some sort of corroboration, some sort of materials, then also there has to be some. The law is that there should be some corroboration. Here, these are different stories. That's what I'm saying.
Get written it down.
Very sad case. In item in division bench item 2021. Where's the landed council for the parties here? 20 and 21. Okay. Okay, then just inform, you record your name in item 21. Record your name and due to paucity of time, let this matter could not be taken up, list after 2 weeks. Just inform them.
Worship,
Yes.
I beg to mention item number 1. There is a small correction in correction need to be in page number 3. Your Worship. There's a typing mistake. Your Worship, may please allow me to correct the petition copy at the course title.
No, it's very difficult. It's handwritten is not supported by CIS. So withdraw and file press.
Oh, Worship.
All right.
Okay.
Is not it?
1.
CIS doesn't support it, handwritten.
No, Lordship, we have to.
Okay, heard Mr.
T. Tatak.
No, Mr. T. Tatak, learned counsel by the petitioner, is allowed to, submits that he may be allowed to withdraw his petition with a liberty to file afresh. Prayer for withdrawal is allowed. Accordingly, the contemporary case stands closed on withdrawal with a liberty to file afresh.
The most of them.
I beg to mention item number 7.
7,
We need some more time for that.
Samraj Tur Chakma. Yes. Who is for the petitioner? Okay. On the prayer, MS K. Wangmo, London State Council. For the 3 weeks time is granted to file affidavit in opposition.
My lord, I beg to mention item number 6, my lord. I need some more time to file the counter.
And then on the prayer, Mr. Tita London is Standing Council Education Department for the 3 weeks time is
Your Lordship, I am for the petitioner.
to file affidavit in opposition. MS M. Hondik. N. Hondik.
Yes, Your Lordship.
Council for the petitioner is present. This is regarding
This is service matter.
Service, my lord.
termination.
My Lord.
Termination.
My lord.
Illegal appointment.
Yes, Your Lordship. Yes, Your Lordship. It's a
Yesterday there was a judgment. Have you come across?
My lord, I could not.
If it is a regular appointment, if it is a appointment and if the service is confirmed, anyhow you even if it's for illegal appointment,
My lord.
you have to follow principle of natural justice.
My lord, that's part.
Discipline proceedings has to be. You have to.
My lord,
Without discipline proceedings or the departmental inquiry, you cannot terminate.
my lord. My lord. And also, man, I beg to mention item number 9. Here also, granted, my lord.
Order. You are for?
My lord, I am the petitioner, my lord.
You are Mr. Your name, please.
Tigami, my lord.
Tigami, Tigami. For petition is present. 3 weeks.
Must have like.
Your Honor, I beg to mention item number 10, Your Honor. On behalf of L. Perme, Standing Council Agriculture, Your Honor. We need some more time to file the affidavit.
Yes, taken consent.
Yes.
Have you informed?
Yes, Your Honor.
You are for petitioner.
Petitioner.
Okay. And Mr.
Tirole.
No, your name?
L. Byung.
Huh?
L. Byung.
L. Byung.
Byung.
Your name is there?
No.
Your
no.
name is there? No.
No.
No, you should say on the prayer of Mr. Yes.
Tirole, Your Honor.
Tirole, Learned Council appearing on behalf of Mr. L. Perme, Learned Standing Council. Agriculture Department. Further 3 weeks time is granted to file affidavit.
3 weeks, Your Honor.
Huh?
3 week time may be given, Your Honor.
Yes, what I said. I said 8 weeks or what? 3 weeks, huh? Mr.
L. Byung.
L. Byung.
Byung.
B-E-Y-O-N.
NG.
Byung.
Yes.
Learned counsel appearing for Mr. P. Tapo.
Yes, sir.
Senior counsel for the petitioner is present. Yes.
And Your Honor, item number 5 also, Your Honor, on behalf of D. Soki, Your Honor.
What do you want? Yeah.
Next time will be given, Your Honor. A 3-month time.
3 months?
I'm not been in progress.
You filed the affidavit here? Okay. On the prayer of Mr. T. Role, learned counsel appearing on behalf of Mr. D. Soki, learned counsel for the petitioner. Let this matter be listed after 3 weeks.
Yes, Your Honor.
Mr. T. Tagum, learned standing counsel, education department is present. Yes.
Much obliged.
May I please, Your Lordship, item number 3, Your Lordship. This matter may be taken up after a week, Your Lordship. I have
Why? What is the matter about?
Lordship, here, the petitioner here in Lordship has claimed compensation. Now, here the issue, Your Lordship, is that verification was done, subsequently re-verification done, and the in that both the verification, re-verification, the petitioner's land, which comes beyond right of way, that also we are considering to that. Now, subsequently, while constructing the road, substantial part of her land has been damaged.
How do we know?
That is the issue, Your Lordship.
How do we know? How the record will determine that?
So, in regard to that, yes,
beyond the arrow, or it is within the arrow, or they have encroached, or I mean, gone overboard. We cannot determine that.
in regard to that, Your Lordship, in regard to Lordship,
What do you want from
Lordship,
this?
I'm praying for next week for hearing.
No, it's not that. What you want? What is your grievance here?
I want here, Your Lordship, that subsequently I have filed few representations, Your Lordship.
Land has been acquired.
Lordship, that has already, my land.
Your land has not been acquired.
Yes, while constructing the road, substantial portion of my land has been damaged.
So
that is,
you file a damage before the damage suit before
for that, Your Lordship, I have filed some representations before the authority.
That will be a mere formula, nothing. We don't know whether this is a damage or not, whether it's beyond the arrow, whether
At
it's
least,
your land or not.
If a verification,
we are not, we don't have, this thing.
I'm not saying a lot. To the extent of the damaged portion,
We don't know whether it's damaged or not. For that, you are not remediless. File a civil,
so
suit for damages.
Subsequent, if a re-verification is done to that extent only.
No.
If findings is there, then is already. If not, then.
Is it a stepping stone for filing a damage suit? Are you invoking 226 as a stepping stone?
Damages suits
will allow you to withdraw to approach the appropriate civil court for filing damages. You are asking for damages only.
Lordship.
For damage, there is nothing like compensation. It's a damage only.
Yes.
You approach the civil court. You are not remediless.
The pictures and subsequent while constructing the road, she is the owner of the. She is having title.
It is not an acquired land. Land has not been acquired.
Not acquired.
Your land has been damaged.
That is beyond the right of way.
You file a suit
according to the verification.
So you file a suit.
Lordship, with certain observation, if can be made, that can be disposed of, Lordship.
But dispose of what?
With certain observation. Lordship.
Respondent.
Respondent number 6.
Who are you?
I'm the chief engineer.
What is your stand?
My stance, my lord, I have been recently entrusted this matter. So, certain file has not been transferred to me. And
Want to dismiss the writ petition? You are seeking, affidavit has been filed.
no any role.
Lordship, what I have submitted, Your Lord, that is their
Saying
stand.
what they are saying.
They are
There
saying,
is an damage to the land of the property, property of the petitioner.
Also would have said that this land is beyond right of way.
Okay, then,
Lordship, I'm not disputing that, Your Lord.
ha, then,
He is considering that.
hmm,
Now,
so,
regarding the damage, we can say.
To that extent, Your Lordship, some observation with liberty to approach before this.
we'll dismiss the writ petition.
Lordship, in state of,
We'll dismiss the writ petition. However, you will be granted liberty
Lordship, kindly,
to approach the civil court as may be permissible under the law. Or else, instead of troubling the court, you withdraw and
I
will
have-
give you a liberty.
I have made the party national highway also, Your Lordship.
Huh?
That while constructing the road, Your Lordship.
You are
Subsequently, Your Lordship,
seeking
subsequently.
damage. You are seeking damages from
Absolutely
this
right,
court.
right, Lordship. Right.
You cannot. That's why.
And to the extent of Your Lordship, my representation wherein I have mentioned, I have addressed to the Deputy
See,
Commissioner.
they are saying that your land has not been acquired. They have nothing to do it. There's no damage. But then you are saying that it is a damage. That will be appropriately dealt with by the civil court. Isn't it?
That's true.
We'll have to prove that there is a damage.
Disputed question of facts, because of that reason.
Not only that. Essentially, you are seeking damages.
Of course.
All right. Which writ petition would not be maintainable. So we'll give you liberty, you withdraw, we'll give you liberty to approach the appropriate civil court.
Lordship, can't be a direction can't be issued, Your Lordship, to the subject to Your Lordships. The representation was submitted, Your Lordship. To that extent, at least if a verification is done
We don't act,
by the Deputy Commissioner.
we
Your
don't
Lordship.
act as a postmaster.
Kindly see, Your Lord, no, I'm not saying, Your Lordship. There are several representations. She's a lady, Your Lordship.
Okay, heard Mr. A.K. Singh, Learned Counsel for the petitioner. Petitioners or petitioner?
Petitioner, only one.
Heard MSG at the Learned Additional Senior Government Advocate. For respondent number? Legal and as well as Mr. Armilo, Learned Standing Counsel for
Respondent number 6.
State Highway.
Yes, my lord.
What is your highway department or PWD highway department?
Highway Zone PW, is that correct?
Highway zone PWD Arunachal Pradesh. What is the file? Dispose of.
Lordship.
Dispose of.
PWD highway.
Chief Engineer PWD highway. Will that. 2 pages order will be there. Will you be a liberty only? Nothing else. Writ petition will be.
Lordship, instead of dismissing your liberty, it's all right, Lordship. Lordship. All right, Lordship, sir.
Your Lordship, may I mention item number 4? I need some time to file rejoinder affidavit.
What is this matter?
This is with regard to reference. Yes, I had filed a reference application before the Deputy Commissioner.
Reference has been made or not?
Yes, application I had submitted before the Deputy Commissioner.
Reference has been made or not?
No, that
Who
was
is for
not.
the respondent? Who is for the deputy collector? When the reference application is filed, why you are withholding it? It's a simple prayer.
It's a simple prayer.
We'll consider. We'll dispose of. We'll dispose it of. Go
Okay.
through it. You have filed the affidavit.
Yes, they had filed affidavit.
Go through it.
This application we had filed in
No, we'll take up when your terms come.
Okay.
You be there.
Item number 2.
Yes, madam.
May I please, your lordship?
Promotion.
My lord.
Seeking promotion.
Yes, my lord.
Consideration for promotion.
Yes. My lord, but my lord, according to this LHV rules, LHV is lady health visitor. According to the rules, 2023 rules, for somebody to be promoted to LHV, they have to have an A&M, 5 years service, plus 6 months course, LHV course. Now what happened, usually what happens?
6 months.
6 months course.
Okay.
That is in service. So the eligibility the petitioners have. What used to happen is that those who undergo LHV course, they used to be given promotion. But in our case, what happened is, in 2024, we have already completed. That we go by our own request and then nominate us because we have to spend our own money. That is also.
Will issue notice.
No. Sorry, saying no to notice. The problem is they are now going to conduct a DPC for promotion, and the seniors who have completed the course much later, now they are going to, as per my instruction, they are going to give. So the DPC.
Problem is they have waited for your seniors to come.
Yes. Despite our repeated representation.
The poster fill up.
Yes.
I mean, promotion DPC is convened.
Yes. They will.
You are junior.
Yes.
Will not get it.
Yes.
Very unfair.
I have seen all the file notings also. They have done it intentionally.
This in case of promotion, my lord, the DPC, my lord, they have to all the person who's eligible, my lord, that's.
But then why when there is a vacancy, when they have already fulfilled, when there is a vacancy, why you have to wait for them?
That is my lord, there may be.
They have not done there because that point of if it was convened, their senior would not be entitled or eligible because they have not undergone 6 months training.
My lord, what was the administrative there may be administrative conviction.
No.
The DPC is it is up to the authority, my lord. Even if DPC.
Are you going to conduct when?
My lord, is the time? There's no time schedule for that.
So we'll issue notice for 3 weeks before that till returnable don't convene.
My lord, for conveying DPC is a better matter. In case if any case, my lord,
he knows.
We know.
That's right, my lord. What I'm saying, if in case.
Even if they are considered, they will not be because there are many seniors.
Yes.
They have given this thing also, statistics, data.
My lord will see the file notings. They have done it intentionally.
24.
They delayed it intentionally. It is in the file notings. Their file notings, lordship.
I understand this. Their anxiety, my lord. But the thing, my lord, this all criteria for eligible for promotion, it is the domain of the departmental promotion committee.
Understand.
But that's why, my lord, if there's any loophole, if there's an irregularity, there's any the illegality in the process, now always if her right, the settled right, if it is violated, if there's the case, my lord, can always be challenged.
Then
but
2 weeks, don't do anything within 2 weeks. You file the affidavit, dispose of the matter. Will it be all right?
He should be fair looking at the file notings. I think he did not go through.
My respectful submission, because it's not a case that her case will.
What is the rule?
Rule is, my lord, page 107.
107.
Rules.
Starts from page 104. The relevant portion is page 107.
What is the name of the rule? This is
Lady Health Visitor, Group B gazetted.
Lady Health Visitor.
Recruitment Rules, 2023. column 11.
ANM with 6 years of regular service in grades and 6 months certificate course as lady health visitors. ANM research. Her MS and Dungan learned counsel for the petitioners.
Yes.
How many?
5 petitions.
5
petitioners. List of. By filing this writ petition, the petitioners are agreed by the agreed by the non-consideration for promotion.
Yes.
Promotion.
It is a promotion.
To
Yeah.
the post of
LHV.
lady health visitors.
Yes.
Within bracket LHB in shorter bracket close. Despite the despite the vacancies and the eligibility of the petitioners, this writ petition is instituted seeking a direction to the respondent authorities to consider the petitioner for promotion to the post of LHB strictly in terms of the lady health, in terms of the provisions, in terms of the lady health visitor group B non-gazette non-ministerial recruitment rules 2023 page 104. List of. It is the specific case of the petitioners that they have undergone. They undergone 6 months certificate course as LHB in the year 2024. And when there was already vacancies for lady health visitors, list of the petitioners being working as ANM and having completed the having undergone the 6 months
LHV.
6 months certificate course as LHB, they are eligible in all respect for consideration to the post of to be promoted to the post of consideration eligible to be considered for promotion to the post of LHB in terms of the recruitment rule. However, the respondent authorities intentionally did not convene the DPC and is and convene at the relevant point of time, depriving the petitioner, and now they're contemplating to convene the DPC, allowing allowing the senior ANM who
Yes.
have been allowing the senior AM who have been allowed to undergo 6 month course belatedly to give preference to the seniors. No, to give undue advantage to the senior ANM who have undergone the 6 months certificate course belatedly. List of issue notice returnable by 3 weeks. Next para. As Mr. P. Tangam Learned Standing Council, Health and Family Welfare Department enters appearance on behalf of all the as well as Mr.
Except three, my lord. 1, 2, 4, and 5.
P. Pangu, London State Council enters appearance on behalf of respondent number 1,
3,
3, and 3.
Only 3, my lord.
No.
And for
1, 2, 3, 4, and 5. No permanent notice need be served in respect of the above respondents. Our extra copies. London Council for the petitioners to take steps for service of notice upon respondent number 6 to 102.
Yes.
Respondent 6 to 202 by registered post as well as by speed post. Make it a speed post. Speed post as well by usual process within 2 working days. Next para. So, interim, obviously you will also be considered.
No, my lord. We have been told bluntly that we won't be considered because we're not seniors.
Then we'll say, no, DPC shall be convened without considering your case.
Yes, my lord.
That will be,
Yes.
because stopping them would be.
Even if we are, if they take seniority, then it's be.
We'll say at this interim,
Yes.
say, no DPC shall be conducted without first considering the case of the petitioner.
Yes, my lord.
In view of the fact that you have undergone
Yes.
earlier to
Yes.
only you have undergone the 6 months certificate.
No, there are 19 persons, 5 of whom have come.
Okay.
Hmm.
Considering that the petitioner's privacy appears to have
My lord, it may.
appears to have found to be eligible in the year 2024 when the vacancy when the vacancy of LHB was available and the respondent authorities has to fill up the post, fill up the has failed to convene the DPC for promotion to the post of LHB in the year 2024. No DPC shall be convened without first considering the case of the petitioners.
Obliged.
It's okay.
In the event of DPC, madam, let the case of petitioner also be considered. That would be.
That may be subject to many interpretations.
That's what I'm saying.
May I suggest, my lord, they may also have a problem with that. Let it be assured that let them come with an affidavit. Till then, at least the DPC can be stalled. So far as they are concerned.
No, let them have DPC.
Yes.
First, when they have decided to convene,
yes,
your case will be first considered.
There may be case, my lord. The
reason is very simple. In 2024, there was a vacancy.
Yes.
You are supposed to have DPC every year.
My lord.
Right?
My lord.
And they were eligible.
My lord.
Now you want to have a, composite kind of thing where the candidates who are not eligible at the relevant point of time has become eligible.
Lord,
So
I believe
deprivation is there.
Madam, that's why
Not much that big, but maybe little deprivation is there.
That DPC, well, considering, madam, they're the person who acquired the.
Or else we will say that if in the event DPC is convened, the case of the petitioner shall also be considered.
Exactly, madam. That's my number.
As they were found to be eligible at the time when the vacancy were there.
Yes.
My lord, the earlier one would be. Sometimes because English is not our first language, is subject to many interpretations. The fact that is.
No, you convene the DPC. Do it consider their case also. First you consider.
But only because DPC generally, madam, that has to be taken into cumulatively because for the sitting and arraignment, it's also there's enters the.
See, suppose there are 10 cases, I mean 10 vacancies. How many of them will be considered? Say 1:3, 1:40. There are 150.
Yes, there's around 100.
And they are much below the thing.
Yes, around.
Obviously, they will not be. Even they will not come on the zone of consideration.
But DPC, what?
Your memorandum clearly says you cannot, or the Supreme Court also say in certain cases, not the specific, that normally every year you have to convey the DPC, which you have done. You had allowed to accumulate the post, and in the process, the candidates have, and more candidates have accumulated.
No, in this case, what happened is not just that, Lordship. In the whole of Arunachal Pradesh, only in Dapurijo, there was this government recognized institute for LHV. What they did is, since there are so many posts, since there are so many seniors, let them study in private institutes. That is what they did. They went up to that extent. Although that is also not permissible, but still I'm not.
Why the authorities are against you?
No, they are not against us, but because there was in 2023, 166 new posts were created. They realized that there are only 19 persons who are eligible. So they wanted more. That is why they did that. But in doing so, they did more than what was required. In the process, will be pushed out now.
Okay.
So if no, it is not premature because the cumulative. If he's saying the cumulative way it is considered.
I pass the order.
Lordship. Oblige.
Item number 4.
The applications for referring my applications to the reference court by the DC, which I had submitted in 2022, and also a reminder.
Yes, what is your state?
The award was passed during 2014.
Huh?
The award was passed in 2014.
Then?
Then he was given the compensation.
Then
the compensation was dispersed.
You have received the compensation.
Yes, but enforcement, I'm disputing some enforcement.
No, when did you?
Just I had submitted
when
my.
Did you file this thing?
In 2022, Your Honor. 2022.
Award was passed in
2014.
14, and when did you receive the?
No, Your Honor, because the order based on which the award was passed, because even the award was in 2012. So our dispute was settled only in 2014.
No. When you were given when the compensation was dispersed.
Compensation was disbursed in 2014 only.
Then you have to, once the award is passed.
Yes, sir.
As per the, if you are agreed by so far as regards apportionment, you have to file a reference application within
6 weeks. Within 6 weeks. But there was some misunderstanding, and this case was filed, brief was come, and all this.
I thought in that case your reference would not be maintainable.
But this is limitation will be decided by the reference court.
No, you'll have to file it.
Yes, I had filed my application stating all the ground.
When?
In December 20th July 2020.
So what is your stand saying that this?
No, they had not taken any stand in this my applications. They had simply said that award was.
I thought it's very simple. It's not that simple as you have tried to project. When the disbursement was, the award was passed in 2012, disbursement 2014. How can you file the?
No, Your Honor, the award was passed before the enforcement was fixed. Enforcement was fixed only in 2014.
Then when did you file the?
2022. Your Honor.
Then after 6 years.
After 12 years. 8 years.
8 years.
After 8.
Then I don't think so.
Your Honor. But even then, I file a reference. Let the time period may be decided by the reference court. That is the only prayer.
Then we'll not dispose of. I thought it's within time.
No,
there's
no, it's
bar,
not
nothing
within
like
time, it's
that.
not. Let me file my rejoinder
Okay,
to
on the prayer of Mr. D.K. Devi, learned counsel for the petitioner, let this matter be listed after 3 weeks. In the meantime, learned counsel for petitioner may file his affidavit, the affidavit in reply on behalf of the petitioner. Huh? May file the affidavit in reply to the affidavit in opposition filed by the state respondents. Otherwise, I could have dismissed it.
Yes.
Nothing.
But
Well,
thing is
that's-
that
you
because
cannot-
after that order, no award was passed for that particular piece of land. But for rest of the land, award is there.
Nothing.
Let
There
me
cannot
file.
be reference now.
I will let me file the
It
affidavit.
is hopelessly delayed.
Of like.
Item number 8.
My lord. My lord, pleading in this matter has been completed. So for next.
Mr. J. Learned counsel for the petitioner, as well as Mr. And also had Mr. Which one? MSP Pangur Learned State Council for Respondent 1 and 2, as well as Mr. B. Fisher Learned Counsel for Standing Council. Ardi, Standing Council for Rural Development Department. For Respondent 3, 2, 3, and 5. Pleadings are complete. List for admission after 3 weeks.
Obliged.
Item number 9.
Affidavit, who is for the state? What is the matter?
It's the steady concept.
Where is? Who is for the petitioner?
Lordship,
Hmm.
I think it was adjourned.
Huh?
It was adjourned.
Item?
9.
John. Who has said? Item 9. Okay.
Item number 11.
11 also adjourn, I think. 10 or adjourn.
Yes, that.
11. Then.
Dear Lordship, service upon private respondent has not been completed.
Third, MS.
Vaigao, Lordship.
Vaigao Learned Counsel for the petitioners. And also Mr. Y. Ridam Learned State Counsel for
Lordship, we may be allowed to take
service report in respect of respondent number
7 to 14, Lordship.
7 to 14.
Lordship, we may be allowed to take dusty service.
Huh?
We may be allowed to take the dusty service.
Then in that, no, then you just said, office note indicates that service in respect of respondent 7 to
14, Lordship.
14, I still have. Next prayer on the prayer of MS Ega. A week's time is granted to take precise steps by dusty mode. List the matter after 4 weeks.
Obliged, Lordship.
Item number 12.
My lordship, here the service report in respect of respondent 2, 3, and 4 are still awaited.
Mr. K. Learned Counsel for the petition. Await service report in respect of respondent 2, 3,
and 4.
3 and 4. This after 4 weeks. Mr. M.S. Vaiga, Learned Counsel appears for appearing for Mr. M. Kato, Learned DSJ is present. This after 4 weeks.
Correct. There is an interim order.
Interim order pass earlier still continue.
Lordship.
Item number 13 and 14.
May I please, my lords? My lords, this is an application for advancement of date and early hearing because if your lordship would kindly have order dated 12th of June.
Where it is?
12th of June. Yes, your lordship's the last 2-3 lines. My lords had asked the government to file affidavits. And the last date for filing of affidavits was given as 20th of July 2026 with an advance copy furnished to Learned Counsel for petitioners. Even that affidavits have not been filed, and which is a total defiance of the Honorable Court's orders. So they are deliberately trying to delay the matter on one pretext or the other. So
what is the matter about?
This matter is about those fake SC certificates in which my lord was pleased to pass detailed orders.
SC certificate.
My lords. So 12th of June's order, if your lordship would kindly have, 12th, 6th.
It's okay, we've seen it. Or Mr.
Mahmood Pracha, my lords.
Mahmood Pracha, Learned Counsel for the petitioner. And also heard Mr. No, this is what? This application is for?
Early hearing, my lords, because on the last date of hearing, my lord had fixed a long date of 28th of August. But they have not even complied the 12th June order till date. They have not filed that affidavit.
What order we have passed earlier?
On 24
Earlier, my lord had passed an order for fixing a date of 28th of August. Because in the morning, my lords, they had mentioned the matter.
See, Mr. Pracha, since they have not filed the affidavit, we find it reasonable to do their prayer.
Yes.
It's not even 2 months or something.
My lord had given them.
In fact, we wanted to give within 20th of August, but then convenient time of your colleagues. So we have granted this.
My lords, my respectful submission is they have not filed the affidavit on the next.
It's okay.
Sorry, my
See, where is the order? In the writ petition, we have passed the order for filing affidavit, right?
My lords, yes, my lord. That is 12th of June 2026 order.
No, before, after that.
After that, my lord, last occasion is.
K. Wangmo so and so and K. London 127. No.
On 24th of July, they have taken a date, my lords, once again. That's my difficulty.
Matter was listed on 24, but
it was listed. Nobody appeared for the petitioner.
No, my lords, in the morning.
No.
And today,
no. See, 24. Nobody appears.
Yes.
Right. The respondents pressed for a time, so we have granted. Looking at their convenient time. Had you been appeared on that day, we could have given it at least 3 weeks, 4 weeks, something like that.
Can I just?
Nobody appears for the petitioner. And
I'm sorry, my lords, but I was only saying this, that they mentioned the matter in the morning, my lords. Our matter was fixed as item number 14. In fact, so in the morning itself, they mentioned the matter, and on their prayer, my lord was pleased to grant. At least they should have waited for us.
See, we'll just keep it pending, your application, since we have already passed the order on 24th.
My
Today
lord.
is what? Today is what?
Today is
Last
28th, my
Friday,
lord.
we have ordered passed. We have passed the order on 24th.
Of course, my lords.
Let us not unnecessary. I mean, this thing, since they have not filed the affidavit, we'll say
Look.
we'll record your appearance, and we'll say if they don't file. I mean, we'll see after 28.
Look, can I just read one line from your lordship's 12th of June's order, if your lordship permits me?
No, it's okay. I've seen that.
So, my lords, at least their opportunity to
See,
file
it's
affidavit
not
will
a
be
sir.
closed.
It's not an isolated case. So when we believe when the learned counsel for the parties makes a prayer, we hear both the parties. Unfortunately, on 24/7, you are not there. I mean, nobody appears for the petitioner. So when the respondents prayed for a time, so we grant them. Looking at their convenience, one of their colleague is a senior counsel from Gauhati. They have given their, they have decided that date only.
My lords, I am
Convenient date of the lawyers only.
Yes,
So,
my lord.
Mr. President, we'll record your their name, this thing, your presence today. We'll keep it. We'll take it up on 29. We'll just say that let the matter be. In the meantime, parties may exchange the pleadings. All right.
My lords, but please, my lords, can
You're
I
right,
request
I-
for at least pass an order for last opportunity to be given to them,
No,
because
no,
they are
no,
deliberately
it's-
not filing affidavits.
It's okay. It's okay. Sir, try to understand.
My lords, I am asking for a simple prayer in this. There is an interim prayer on which this affidavit has to be filed after my lords passed a detailed order on 12th of June. My lords, this way, the very purpose of filing this petition is getting.
M. Pracha, learned counsel for the applicant, writ petitioner. This is an application seeking early hearing of the writ petition being the early hearing of WPC 497 AP of 2025. Next para, issue notice returnable by 3 weeks. As Mr. Who else are appearing? As Mr. All are represented.
Yes.
As Mr. Y Ridham Learned State Council, comma, Mr. Which one, two?
One
Serially, chronologically.
I'm depending for two.
Mr. T. Gadi Learned Standing Council
Yes.
for Arunachal University.
No.
Sajata, huh? SJET Department, comma, K. Lowland for respondent number 7 to 26 and 17 to 26, 16. And no comment notice need be. However, extra copies be furnished to the learned counsel for the respondent. Rest of the learned counsel for the petitioners to take steps for rest of the respondents. You take steps for rest of the respondents, right? In writ petition, you said you write, record your name. Same. Since the matter has already been fixed on 28 8/2026 on the prayer of the respondents, including the on the prayer to learned counsel for the respondents, Mr. T. Gadi, and who else are there on that day? No, on that day, who else are there? No, K. Wangmo, MSK Walan State Council, and D. Pangi. You'll just see the last. D. Pangi Senior Council for Respondent number 16 in so. K. Wangmo, State Council for Respondent 1 and 3. T. Gadi, K. Lowland, and Mr. PJ learning senior constables. No, you were there. Okay. No, in that case, last order, huh? T. Gadi, then standing counsel, and Mr. PJ learning senior counsel put the response 17 to 27. The matter be taken, the writ petition shall be taken up on 28/08/2024. In the meantime, parties may exchange their affidavits. In the meantime, parties may exchange their pleadings.
Let's last opportunity may be given. That is what I'm requesting, because many opportunities have been given.
Worship matter is over.